Me.
My brother wants to ask.
Yes.
He just wanted, in your formulation, if I may draw your attention to the reference question may have to be reformulated thus.
Yes, my lord.
Point 8.
Yes, my lord.
And there you have said, if you just come there,
Yes, my lord.
You may just read it once, and so that I'll just point out where I am.
Because I have unilaterally sought to delete some words.
So that's right. So just read it so that we'll all appreciate it together.
Now that the argument has been made, your lordships will be in a better position to appreciate.
No, there. So what you are saying is whether the statutory bar contained in section 35 of the Stamp Act applicable to instruments. Point 8. Page 5. Page 5.8.
No, so I've tried to reformulate the.
That's right. So just putting it across to you. Applicable to instruments chargeable to stamp duty under section 3, read with the schedule to the Act, would also render the arbitration agreement contained in such an instrument. Then you have struck out few words.
Yes, my lord.
As being non-existent. I'm just pausing here.
Yes.
As being non-existent, should we say, because of the words that you have incorporated thereafter, non-existent temporarily?
My lords, I have just used non-existent because the section uses the word existence.
No, correct.
Yes.
So non-existent
Temporary.
because pending payment of stamp duty on the substantive.
Right.
So it is non-existent. You are not saying for not forever.
My lord,
obviously for the limited time until the stamp duty.
I am
is
going
paid.
one step further, my lord. I am saying it is existent, but it is not enforceable. It exists today in present time. So, my lord, non-existent would be it would not exist, but it exists today in fact and in law. Today, there is in an unstamped agreement, my lord, the submission is that as on today, assuming an agreement is unstamped, it exists as a matter of law because it is, my lord, a valid agreement. It is only, my lord, a curable defect by which that defect can be removed and it can, my lord, be then implemented. So, my lord, I am going.
So non-existent, then should you not qualify that with something?
With something, my lord, yes. Possibly temporary.
You may think about
Yes,
it. I'm just putting it across to you because
yes, my lord.
You are trying to reformulate.
I am trying to, my lord, reformulate it only. The reason I didn't want to tamper too much, my lord, with the.
So just think about it. Something may have to come here.
Something may have to come.
Very well.
Please. My lord, now the reference judgment in Garware. I was showing your lordships the Garware judgment, which is the sheet anchor, my lord, of the basis of the reference. Justice Nariman's judgment. Have your lordships
Yes.
got that judgment? My lord, the relevant paragraphs that are fall for consideration before this court are paragraphs essentially 18 to 22 and 28, 29. Those are the ones, my lord, which are also, my lord, have been referred specifically to the Constitution bench, particularly 22 and 29. So, my lord, I have some comments on these paragraphs and some, my lord, criticisms which one makes with trepidation. After all, my lord, it is a judgment of this honorable court of 2 honorable judges. But I have in my favor, my lord, 3 honorable judges who have not agreed. So I can, my lord, legitimately make some criticism, even, my lord, though it is a judgment of this court. So, my lord, with that caveat, my lord, may I say some things about this judgment. Please, my lord, insofar as paragraph 18 is concerned, which is at page 22, which your lordships had seen on the last occasion, my lord, internal page 230 of the judgment, the division bench observes that it will be noticed so and so. It is settled by SPP and company that section 16 of the 96 Act has full play only after the arbitral tribunal is constituted without intervention of the court under 11. Lord, this qualification was added by the 7 judges. They go back to the concept of court with intervention of court, without intervention of court. That aspect, my lord, stands legislatively overruled, though that ghost of, my lord, SBP still seems to haunt us. It is also referred to in Justice Khanna's judgment, because after all, my lord, 7 judges, it's difficult to reconcile the fact that the legislature has, my lord, changed the rules of the game, as it were, but it has, my lord. 232, my lord. Page 24. In view of the law laid down by the 7 judge bench, difficult to exceed the argument made by learned counsel on behalf of the respondent. Section 16 makes it clear an arbitration agreement, independent existence of its own, must be applied while deciding an application under Section 11. Well, Lord, I would respectfully submit that this may not be quite correct. Certainly, when deciding what is the scope of 11.6a, your lordships will also take into account Section 16 and give it whatever the meaning that it is to be given, not without going into whether it was intervention of court. That's one criticism. My lord, 19 and 19, my lord, is another paragraph which one is criticizing, my lord. And I'll explain why, my lord, what the problem here is. It is seen that neither in the statement of objects and reasons nor in the Law Commission report there is any mention of SMST estates. Correct? This is for the very good reason that the Supreme Court or the High Court, while deciding a Section 11, does not in any manner decide any preliminary question arises between the party. No problem.
No, one thing.
Yes.
No, the paragraph 18 itself.
18.
You said that no, it is the bench said it is settled by in so and so that Section 16 of 1996 Act has full play only after the arbitrary tribunal is constituted, without the intervention.
Without it.
That may be one reason may be there, because see under 16, jurisdiction that can be decided, existence, and then the other question. So 3.
But
But
existence, validity, and jurisdiction.
Validity. These are the 3.
Right.
And then intervention of court under 11. 11, of course, we know that the examination should be confined to existence. So once existence is decided by the court, full play cannot be, because existence already the court entered into a finding.
That was the.
So if intervention is not there on all the 3, jurisdiction, validity, existence,
that was,
therefore full play. That may be the reason why they went upset like that.
That was the reasoning given, my lord, by the majority in SPP. That was in fact the reasoning given. But, my lord, but as it happens, my lord, the legislature has, my lord, taken a different view, and it says notwithstanding any judgment, etc., of any court, and specifically, my lord, SBP is mentioned in the discussion, and catena of judgments now your lordships have held that it is overruled.
The other day also we put the question.
Yes.
Section 11, it is the same power. Can you say that that particular power can be, or it can have full play only if the question is, that particular question is answered in the negative, and in the affirmative?
My lord, if it is answered.
Affirmative, it can only be a prima facie
If it is answered and negative 16 doesn't come in at all.
Definitely.
It's over.
Definitely.
So, but if
had that been the intention, the legislature would have specifically stated so, especially taking note of the fact that in 1940 Act, Section 33, there that question can be considered and answered only by the court.
Only by the court.
Only by the court.
Now,
so that was the position.
The
so if it has to be changed in toto, it would have been specifically mentioned.
My lord, in fact, the section actually says, notwithstanding any judgment of the to the contrary, including judgment of the Supreme Court, my lord, it shall confine itself. My lord may just see that provision, and the legislative history also seems to suggest that the reasoning of SBP, my lord, is not something that we are my lord, going back to. There is an issue there, my lord. Your lordship may still feel SBP survives, but that seems to be the legislative intention.
That is why we said that no harmonious construction is required. Otherwise, the power under Section 16, we will have to say that it is limited, and it is conclusive only if it is said that it is not in existence.
Right, my lord. That
Existence, it can only be a prima facie conclusion.
yes, my lord. That's how your lordships have reconciled it in that Mayavati. Anyway, my lord, I will this question, my lord, to the extent it may not strictly arise, because, my lord, here we are looking at something beyond existence. In this case, my lord, we are not discussing on stamp duty, my lord. We are not questioning, my lord, my
You put that question only because you have made such a submission.
No, my lord, I am making that submission only on the basis of the other three judge bench judgments. This is two judge bench. There are three judge benches. All have taken that view. I'll show those on Mayavati trading. The same learned judge has taken the view in my lord subsequent judgments in three judges. So, my lord, I just
concern is not so much about existence or non-existence or even non-payment of stamp duty. Concern is over admissibility of
Yes.
a document which contains the arbitration clause.
Correct, my lord. So, my lord, therefore, this issue that because I'm extremely grateful for that observation, my lord. But this judgment, let me place this judgment, goes only on the basis of existence. That's the problem with the judgment, my lord. Why, my lord, is this judgment be referred has been doubted in NN Global? Because the focus in this judgment, my lord, is only on the phrase existence in law, which, according to me, my lord, has nothing to do with stamp duty. That's a completely separate question, my lord. So, my lord, let me just place this. What is the problem? So, my lord, 18, debatable, your lordship has put it to me. I will not put the point. Please focus on, my lord, 19 and 22, which is specifically referred. Then, my lord, the third sentence. The Supreme Court or the High Court is only giving effect to the provisions of a mandatory enactment, which no doubt is to protect revenue. There's no analysis of 33, 35. What is the effect? Whether it is a valid agreement which requires stamping or not. It is a statement that since that is mandatory and you have to then follow it. The clause, as has been conducted, no dispute. Then last line, it is clear, therefore, that the introduction of 11.6a does not in any manner deal with or get over the basis of the judgment, which continues to apply even after the amendment of 11.6a. My lord, I would respectfully submit that the introduction of 11.6a and the language of 11.6a actually gets over the SMST estates problem. Then, my lord, 20 and 22, my lord, are critical. Looked at from a slightly different angle, an arbitration agreement which is contained in an agreement or conveyance is dealt with in 7.2 of the 96 Act. My lord, interestingly, 7.2 also has arbitration agreements, whether contractual or not. So you can have an arbitration agreement in respect of non-contractual matters. That is how
National Highway Authority.
My lord, even tortious matters can be referred to arbitration. So, my lord, in fact, it is a copy, cut and paste of the model law, which is a copy, cut and paste of the New York Convention. So, Article 2.2 of the New York Convention becomes Article 7 of the model law, which becomes our Section 7. No difficulty. We are concerned with the first part of 7.2 on the facts of the case. Therefore, arbitration clause that is contained in some contract in question is subject matter presently. It is significant that an arbitration agreement may be in the form of an agreement clause in a contract. Now, my lord, the learned judge now refers to certain provisions of the Contract Act. And, my lord, I would respectfully submit that this is absolutely important for us. Sections 2A, 2B, 2G and 2H read as under. My lord, I would pause here for a moment. Before your lordships come to para 22, please see the Contract Act, because something turns on this. And Justice Nature said. But section 2 is the interpretation clause. A, B, C, D, your lordships will ignore. 2E. 2E is every promise and every set of promises forming consideration for each other as an agreement. So, my lord, agreement is treated differently from a contract. F, promises which perform consideration, my lord, F, your lordships will also not note. 2E, your lordships are noted. Then G, H, which is quoted in Garware, but please also note I and J. There are 4, my lord. There's an interplay of 4. G, an agreement, and this is where the phrase comes, my lord, not enforceable by law is said to be void. H, an agreement enforceable by law is a contract. I, an agreement which is enforceable by law at the option of one or more parties is a voidable contract. And J, my lord, a contract which ceases to be enforceable by law becomes void when it ceases. So, my lord, four aspects your lordship will see. My lord, G and H are two sides of the same coin. G is an agreement not enforceable law, result void, and enforceable by law contract. So, my lord, this is a binary choice. I and J, my lord, is voidability, but the agreement has already, my lord, become a contract and can be avoided. And J is, my lord, a contract has already happened, and later, if you later it becomes void, then it ceases to be enforceable. So, my lord, this is this is clear, my lord, from section 10 also of chapter 2. Contracts, voidable contracts, and void agreements. What agreements are contracts? Not all agreements are contracts if they are made with free consent, competent to contract, lawful consideration, and are not expressly declared to be void. So, my lord, then the chapter it goes on to show what contracts are void, what contracts are voidable, etc., etc. Your lordships are familiar with this. So, my lord, in this light, I will also show a very short judgment of Justice Nijjar on these provisions of the Contract Act. In Swiss timing, I'll show that. But now please come back to para 22. When an arbitration clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. No problem. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. I, my lord, respectfully submit that this is an error. This is really the error, my lord, in the judgment. Because under the Stamp Act, as I have, my lord, sought to demonstrate to your lordships, the unstamped agreement is a valid contract, valid under law, may be inadmissible in evidence. If I put it the other way, my lord, it is not a 2G situation where the agreement is void due to non-stamp. It is not void. My lord, 2G is only enforceable, not enforceable law. Consequences void. So, my lord, it is not void. If it is not void, it is valid. And if it is valid, my lord, it is a contract. So, my lord, this is where the error. Therefore, even on a plain reading of 11.6a, when read with 7.2 of the Act and 2H, my lord, 2G has been missed out, we would make it clear arbitration clause in agreement would not exist when it is not enforceable by law. My lord, in fact, it is enforceable by law in the sense that it is not void. Enforceable by law has been explained as not being void.
Because it is curable.
Because it is curable. I am obliged. Because it is curable, it is not void. If it is not void, it, my lord, exists as a matter of law. If it exists as a matter of law.
What do you mean by enforceability or unenforceability of an instrument?
My lord, yes. Please see G.
No, what do you mean by enforceability as you understand?
My lord, it is enforceable by law.
Huh. So how do you enforce a contract instrument?
Sorry, my lord.
How do you enforce a contract? Let's take the case of a contract.
My lord, you enforce it by, my lord, putting it before a forum, and my lord, and then, my lord, proceed.
So when you say it's not enforceable in an unstamped condition, would it not mean that you cannot enforce the rights flowing or the liabilities arising therefrom pro court of law or any other
My
forum.
lord, enforceability has different
It's in
meaning
that sense, perhaps.
in that sense. But my lord, the conclusion is that it does not, would not exist.
See, for
That's the
example,
conclusion.
take for example, there is an unstamped document.
Right.
Without reference to the court, parties actually receive payments,
Yes.
perform their obligations under the contract.
Right.
In that sense, of course, it continues to exist.
My lord,
One way of looking at it.
yes, my lord,
But
that's what
the
I'm.
possibility part is to be viewed from the perspective of a party going to a court
Or a dispute. Yes.
and seeking to actually get the sanction of the law to actually make the other party respond to it.
My lord,
So that there it
Lord,
runs into a problem because you can't enforce it because it can't be used.
there are, my lord, if I can put it in simple terms, 3 concentric circles. One is, does it exist as a matter of fact? That's the most narrow view you can take of existence. That yes, the document says A, B, C, D, E, F.
If it exists.
It exists. My lord, the second in which I am canvassing for your lordships, because we are known only on the word existence, my lord, because the one section says existence, section says existence, validity, one section says jurisdiction. So, my lord, existence, option 1, only in fact. That was argued in my lord, in this case. I am not going for such an extreme proposition that all that the appointing authority has to do is to read the document and say, all right, that clause is there, good enough. No. My lord, I concede for the purpose of this, my lord, argument that existence must also mean existence in law. Now, in my respectful submission, my lord, existence in law means that it is, my lord, valid. Because that's the second word, my lord, valid. I.e., it is not void, my lord, void and valid. If your lordship sees G and H, the two sides of the coin, void and, my lord, not enforceable is a contract, and
Implication of inadmissibility.
my lord,
That we'll have to address.
implication of inadmissibility, my lord, is the third stage. It's the largest of the concentric circle, my lord. Stage, if, my lord, your lordships are now interpreting 11.6a existence. That's the word which is used. 11.6a existence, does it mean existence in fact? That's too extreme. Does it mean existence in law? Yes, certainly the court.
Existence in paper.
My lord, it's a valid agreement. Every judgment under the Stamp Act says it's a valid agreement.
It's a valid agreement, but unless becomes
Lord,
enforceable.
There, my lord, your lordship has to see the language of 2G. Not enforceable by law.
Yes, so
Is said to be void. My lord, that expression has to be given the meaning. It is not, my lord, it is not generally we are saying whether it is enforceable or not enforceable. The question is validity or voidness. Then, my lord, we come to admissibility. Admissibility, my lord, classically is a matter which is left, my lord, to the adjudicator, the arbitration, the authority.
here 11 court becomes the adjudicator.
My lord, that's
as far as the existence of the.
My lord, that's the question, my lord. Does it become the adjudicator? The moment, my lord, we come to that stage of saying it is adjudicating or deciding, is it deciding existence?
Mr. Banerjee, what is our job then?
My
Come
lord,
to High Court or Supreme Court
my lord,
just to tell us that in this paper there is an
my lord,
clause
unfortunately, my lord, that is the limited scope of 11. And unfortunately, my lord, it has been placed before the court. And my lord, what your lordship's job is, if I can respond straight away to it.
Job is primarily to name the arbitrator.
No, my lord. I will give your lordship what is within the scope of 11. And please see, my lord, Swiss timing. Please see Swiss timing because it explains the scope. It is not a ministerial or post office, my lord, that is being done. It is a narrow scope, but it is still a scope. I'm not saying, my lord, it's a post office. I'm saying there is a scope, and please see 2014, 6 SCC 677. My lord, your lordships are essentially acting as the appointing authority.
So we have to see the value. Don't we have to see the eligibility criteria?
Sorry, my lord?
If we are acting as appointing authority,
Yes.
then eligibility.
Yes, my lord.
criteria
Your lordships will have to see whether notice was given, whether it is premature, whether the procedure has been followed, whether there is an agreement, whether it's a, my lord, a legal agreement. All these court has to see.
Swiss timing, which proposition you are?
My lord, Swiss timing is only, it's a order of a single designate judge. So it has no, my lord, precedent value. But it is a judgment, my lord, which this is 2014, 6 SCC 677.
Not many in the Supreme Court can have a privilege of this kind of a reported judgment.
On
Single bench.
Single bench. My lord, earlier this single bench used to happen in section 11
Only
because it was a designate judge. So, my lord, some of these, in fact, in Swiss timing, the learned single judge actually sought to overrule Radhakrishnan Maestro. So, my lord, I am not going on the merits, my lord.
Only in this jurisdiction.
I am only showing paragraph 25 and 26. 25, 26, 27, my lord. 25 starts at, my lord, 691. At 25, I'm not going to no, this is on voidability and voidness, and then 26. What is said, my lord, at page, at para 26, at 692, the cases where a clause is patently void are cases where this court, my lord, or indeed anybody will finally, my lord, stop the process. If you can find, my lord, that the clause is patently void, then you will, the appointing authority, my lord, court will not appoint somebody and find that this clause is such that regardless of the fact that it is there, it is ex facie void and an appointment will not be made. Even voidable cases of voidable, my lord, agreements ought to go to the arbitrator to decide, my lord, on the merits. So now that's 27. And 28, my lord, is the ratio of the case. So, my lord, if one can go back to 11, 11 is a provision which is only triggered when parties do not agree and the court is to act as an appointing authority. Only when the procedure fails. It's not a, well, it was never conceived to be a court of any detailed inquiry. Vidya Drolia, my lord, also makes that clear. Every single judgment, my lord, even SBP, my lord, makes it clear.
There is yet another single bench judge.
Sorry, my lord?
There is yet another single bench justice, another house. Single bench judge.
Justice Rao's judgment, my lord.
I think it is there. There is.
For the aspect of fraud covered, whether fraud not covered, that, my lord, Aya Swami, that there is a series of judgment. I am only relying on this for the analysis of the provisions of the Contract Act. That's the only reason, my lord, I am relying on this. And
So
therefore,
the argument is that under the Contract Act, an unstamped agreement is not void.
is not void.
And even if it is unenforceable, it is still not void.
My lord, it is I'll just read this. my lord.
Because that's a curable.
Yes, my lord, an agreement not enforceable by law is said to be void. So it is not an agreement, it is not such an agreement. Otherwise, the natural consequence of that would be that it would be void. It is not void. My lord, it cannot be argued that it is void today.
What does the Stamp Act do actually?
My lord, the Stamp Act,
It enjoins the court from not looking.
my lord, the Stamp Act only impacts, as your lordship put it, admissibility.
Yes.
Right. Now, my
If
lord,
document is not admissible.
admissibility. My lord, it is an evidentiary bar.
Yes.
It is an evidentiary bar. My lord, I'll come to acted upon separately. It is an evidentiary bar.
Yes.
That
Now-
evidentiary bar,
Posed this question yesterday. When to refer a matter to arbitration, to appoint an arbitrator, it's implicit that we'll have to look at the document
my lord, that,
in which there is an arbitration clause.
my lord, that will not
Whether-
tantamount to either admission.
Clarify that stand. What you
Yes, my lord. My lord, there are two ways in which section 33 and 35 will not apply, my lord. I will put them, my lord, at the end along with the compilation of judgments on the 1940 Act, what was the position under the Stamp Act. I'll show that. I will contrast this. And my lord, this specific question of evidentiary bar and my lord, not admissible and not acted upon, my lord, I will deal with separately. I am only at this stage showing the errors in the reference judgment. Because this, my lord, in my respectful submission, my lord, 22, he says, 2H of the contract would make it clear that an arbitration clause in an agreement would not exist when it is not enforceable by law. My lord, this does not appear to be, with respect, correct, because, my lord, it does not take into account 2G and it does not take into account the Stamp Act series, because it's not really being, my lord, considered. So that is all I am saying, my lord, about this portion of the judgment. There is no discussion about curability, validity, voidness. There is no such discussion. It's a simple conclusion based on the provisions of the Contract Act, with respect do not appear to have been read in the way, my lord, that I am submitting. Your lordships may read it. So 22 is, according to me and according to, my lord, a 3-judge bench, a matter which your lordships should look at. That's what we are saying. My lord, your lordship is Wellington Associates Kirit Mehta is that Justice M.J. Rao's single bench. That was, yes. No, that all that went up to that SBP route. In fact, Justice Rao's judgment was then taken, and, my lord, in the reference that was also cited. So, my lord, the other paragraph of this reference judgment, which is the subject matter of doubt, is para 29.
Para 29
Of Garwari.
of
Now, 2 paragraphs were spotlighted by the bench in NN Global. Para 22, which I, my lord, respectfully submit, does not summarize the law correctly, and NN Global was right in doubting it, because it is not a question of non-existence.
NN Global says this agreement is not to be stamped.
Sorry?
NN Global say not to be stamped.
NN Global, my lord, frames the question. It is a matter, my lord, where my lord, NN Global finally says all sorts of things, but
No, but I think 20.
yes,
22,
yes,
23
yes,
is not to be
24,
stamped.
25, 26.
Not to be stamped.
Yes, I'll place that also.
Says the arbitration agreement does not require stamping under the Maharashtra Stamp Act.
But this act is also corresponding same.
Same thing.
Because
Section number may be 33.
So principally the same.
Principle is the same.
My lord, now your lordships will see 28 and 29, because
Have you
20.
examined from this context also?
Sorry, my lord.
Your line of argument is that it has to be stamped.
My lord,
How to come out from the rigor of stamping? Have you
It has to be
examined from
stamped.
this context also that it is not required to be stamped.
My lord,
Because if it's not required to be stamped,
my lord, I can't.
more easier.
I can't argue that. On Tuesday, my lord, that appears to be a problem with that judgment, my lord. It will require to be stamped at some stage. Even a standalone arbitration agreement may require to be stamped. It may require to be stamped. So, my lord, that's why I started by saying that I have some difficulties with NN Global also, and I have some difficulties with Garwade also. But your lordships will have no difficulty.
Proposition is brought in Maharashtra
Yes.
Amendment 2C, I think.
Yes.
That puts in the.
So, my lord, that's the benefit of, my lord, being before a 5-judge bench where lordships can lay down the law and your lordships are not bound by the reasoning of either of the 3 judges.
I was examining this in context yesterday. See the Stamp Act and Article 5C, any other agreement and all.
Yes.
A and B are in different contexts.
A and B are.
C is residuary.
C is residuary.
So C has to.
I am obliged, my lord.
Only
In fact, my lord, there are.
Taking the principles of as a generalist of A, B, and C in the light of context, can't the paragraph 22 of the judgment under reference?
My lord, there are some.
Proves the view.
Possible, my lord. I had not thought of it in that way, my lord. But there are some judgments which. That is what your lordship is.
If we take in totality of the matter,
My lord, that may
the very
be.
purpose of arbitration because of this trigger here is going to be frustrated. Ultimately, we want to see the system to make workable and effective.
That's right.
But we just take the short routes somewhere else, and the main dispute arising from the contract to be resolved by the arbitrator goes somewhere else.
That is football, my lord.
Football. So to sum up and to put the things into order and see the dispute among the parties.
My lord, the starting line must be crossed.
Focused and effectively deliberated is cited.
Well, starting line has to be crossed in the marathon. When you start running, you have to get past the starting line. If you are stuck at the starting line, then there's a problem. But then you go off on a tangent somewhere else, go to the district collector, and then, my lord, it's all over.
The analogy of marathon may not be correct because the process is expected to be a sprint run.
Right. Sprint run. But it is a marathon. That's unfortunate because I am taking into account, my lord, award, appeal, execution. But I was doing an execution, my lord, in a matter. I was doing an appeal in a matter, my lord, before another bench, where the matter had started in 1960. Argued arbitration conducted by my late father. Then the setting aside in Calcutta High Court in the 80s conducted by my brother, and then, my lord, in 2020 it had come here. So, and it was 7 lakh out.
It is all the more necessary we should keep in mind that if this is the fate of the arbitration,
We should.
then we have to.
But, my lord, situation has improved, my lord. The arbitrations have speeded up because of this new law. There's a difference. The arbitrators are also under some pressure to my lord, expedite matters. Though there are, of course, my lord, some cases where even that has not made a difference. But certainly.
That McDermott matter.
That was, my lord, this was J Engineering work.
McDermott also.
Also, my lord, took its own time. The lordship is there.
Has it attained conclusion?
Yes, my lord, we got 5 lakhs at the end of 1960 award. We got 5 lakhs.
Because I am in a
We
matter.
thought whether you'd be passing it as an heirloom. to your son.
No, my lord. Fortunately, no member of the family is a lawyer, my lord. That's the good part is no member of my family, my lord, of next generation has thought it's an unfit profession, my lord. They think we work too hard.
Because I am in a matter for enforcement of a foreign award. The arbitration proceeding took 2 months. Award came in 2010. I came to India for enforcement NAGPur. It's been 13 years. Amount recovered is 0. All courts, including this honorable court, recorded judgment in my favor. But review has been filed, everything has been stopped. Court said, I will not book it. Everything is pending. 13 years, nothing recovered. In execution of a foreign award.
But now possibly you might get interest.
No court is giving the money, even the amount which is deposited, which is the INR amount, I have not been able to withdraw. Because it says review is pending in Supreme Court, nothing doing. You will not touch. So this is one situation.
Is somebody there amongst us to address on the view expressed by a reference?
There are other people, my lord, who may support that view, my lord. It may be, my lord. I am taking a very conservative approach because there is a very old judgment, my lord, 1800 judgment, which says arbitration.
No, you argue number of cases. You find your name everywhere.
Garwani was argued by me, my lord.
My lord, on the other side.
Also argued by me, my lord. Side effect for the petitioner in any group.
And now you are watching now.
Which escaped to my lord.
My lord, may come to paragraph 28 and 29.
The only thing which I feel, my lord, is the issue of section 9 application. And if an objection is taken, my lord, there may be some time taken for my lord because the document will have to be impounded. That's the only grey area which I think perhaps your lordship may need to tweak, my lord. Because, my lord, the idea of a section 9 is to, my lord, get an urgent interim, my lord, order. Or if, my lord, an objection is taken, that, my lord, the document is unstamped, Lord, then it is going to take time. Unless, my lord, your lordship agrees with, my lord, Justice Nariman's view in Garwani, the last paragraph, where it is indicated, my lord, that they will make it time-bound, my lord. If your lordship has para 37 in Garwani, my lord.
My lord, that.
Otherwise, my lord, section 9, my lord, the very purpose, my lord, would be frustrated. That's the only area where I feel, my lord, some tweaking may have to be
9
done.
is a more difficult territory.
My lord, 9, I am not going into 9, my lord. 9.
I will, my lord, submit on that.
Otherwise,
We are on 11.
But my lord, I will show that based on what my lords will hold, my lord, 9 is going to be substantially.
No, 9 is pending separately, my lord.
the full bench judgment of
The full
Bombay High
bench
Court.
judgment is pending separately, my lord. So let's not, my lord, expand the canvas. Then I will have, then 9 we will go into, my lord.
My lord will have to notice it, my lord. Otherwise, if it is not argued, my lord, that aspect will completely get missed out.
My lord, your lordship, restrict to the reference and restrict to.
This bench is a creature of the reference. So,
Please, my lord, I will show
confined to
that why 9 is referred in both judgments, my lord, and therefore it can be looked at.
Yes. My lord, may come to para 29, which is page 30. This judgment in Hyundai engineering case, your lordships have got page 30. This judgment in Hyundai engineering case is important in that what was specifically under consideration was an arbitration clause which would get activated only in insurer admits or accepts liability. Since,
Mr. Banerjee, which judgment you are?
my lord, I am still on Garwani.
Para 30.
29. This is the other para which was highlighted, my lord, by the bench. The judgment in Hyundai engineering, and I'll place Hyundai engineering, my lord, because it has some relevance, is important in that what was specifically under consideration was an arbitration clause which would get activated only if an insurer admits or accepts liability. You know, this is well known as the Scott and Avery clause. Since on facts it was found that the insurer repudiated the claim, though an arbitration clause did exist, so to speak, in the policy, it would not exist in law, as was held in that judgment when one important fact is introduced, namely insurer has not admitted accept liability. Likewise, in the facts of the present case, it is clear that the arbitration clause that is contained in the subcontract would not exist as a matter of law until it is duly stamped, as is being held by us. Argument that 11.6 deals with existence as opposed to 8.16 which deal with validity of an arbitration is answered by this court understanding of the expression existence in Hyundai. So, my lord, the two-judge bench takes recourse to two reasons. One is para 22, where Contract Act is taken into account, and, my lord, 29, where it purports to follow Hyundai. What it says in Hyundai, something was there, taking an analogy, taking a parallel, the clause here does not exist in law. Now, my lord, the very interesting fact about Hyundai is this. Hyundai is quoted at para 28. The judgment in Hyundai is considered, my lord, by the two judges in Vidyadrolia. One judge says X, one judge says why. So, my lord, specifically with respect to Hyundai and the reasoning in Hyundai, two judges of this court take two absolutely opposing views in Vijayarolya. And my lord, that is also there in Justice Khanna's discussion of Hyundai is in paragraphs 113 to 115 and conclusion is at 146, 147. And the exact opposite is in Justice Ramana's judgment at 201 to 203 paragraphs. So, my lord, perhaps your lordships will have to just examine, my lord, what actually Hyundai says. It is something, my lord, which tangentially comes into the reference because that is an argument which is now accepted by the, or rather a weapon or rather a reason used by the two judges to justify its stand that the clause does not exist in law. And it says the reason I am saying this is because Hyundai similarly said it. You know, this is the 28 my lord, Hyundai has been set out. Now 26 and 27, my learned friend wants to show Enercon, my lord, and Duro Felguera, according to the bench, does not, my lord, answer the issue, is what the bench says. But I say, my lord, it does answer the issue. And 28, then Hyundai is considered this three judgment. Now, my lords, if your lordships now turn, before I go to Vijayarolya, because 2-3 paragraphs of Vijayarolya have been put in the reference. I just wanted to take 5 minutes on this Hyundai dispute. My lord, Vijayarolya was a matter with a limited reference. The only issue, my lord, there were two issues in Vijayarolya. What happened in Vijayarolya was it was a section 11 matter. It was a landlord-tenant dispute and it was a section 11 matter. I'll just give that background and show the relevant paragraphs. The question that arose before the Supreme Court was, for rent control matters, of course, it is not arbitrable. There is no subject matter arbitrability. It is hit by section 2, subsection 3. It cannot be arbitrated. But the question arose whether a landlord-tenant dispute would be the subject matter of arbitration as a matter of law. That was the only question before the two-judge bench in Vijayarolya. So, my lord, Justice Ramana framed two questions. Lordship will just see the questions which were framed. Questions, my lord, are framed at page 157 of this compilation. You just see Vijayarolya. I am conscious that the lordships do not wish to expand and reopen all sorts of aspects of Vijayarolya, but I am only limiting myself, my lord, to the reasoning with the stamp aspect. Page 157, para 165, if your lordships have. The reference order primarily indicates that there are two substantive issues to be settled by this court, namely, one, to what extent does the court decide the question of non-arbitrability, namely subject matter non-arbitrability under 11 of the Act, 165(2), whether tenancy disputes are capable of being resolved through arbitration. This was the limited scope of the reference in that case, nothing more. And in fact, the concurring judgment, Justice Ramana says, having answered question 1, that normally this matter should be left to the arbitrator, I would not have gone into question 2 at all. But since it has been gone into, I agree. So, these were the only two questions that were referred. As it happens, in the judgment of Justice Khanna, my lord, which we tend to read initially, a very large number of issues have been discussed. The scope has become quite wide, my lord. And one of the issues which has been discussed, my lord, is what is the meaning of arbitrability. This word does not exist in the Arbitration Act. There is no phrase arbitrability in the arbitration. Arbitrability may have different meanings. The narrow meaning which Justice Ramana, my lord, takes is, I am only deciding on subject matter arbitrability. I am only deciding on the question of section 2, subsection 3, whether it is the subject matter which is arbitrable or not. That's all. Justice Khanna goes 2-3 steps further. He decides not only que subject matter arbitrability, he also decides on another question which actually is really not a question of arbitrability. Not that question is a little different. If you have arbitration clause X, there may be certain, my lord, accepted matters, matters which are not to be referred to arbitration. For instance, my lord,
2.3, section 2, subsection 2.
2.3, my lord, was the reference. 2.3 is clearly to be decided here, my lord. But what Justice Khanna has done in para 15 is that he has decided, my lord. There's no problem with that. He has made a fourfold test. He has said what is arbitrable, not arbitrable, in rem, in personam.
Within the arbitration clause.
Yes, fine.
Your worry is about within the arbitration clause.
My lord, yes. My lord, now the issue that is there in Hyundai is little different. Issue is, supposing you have an arbitration clause. There's no dispute to have an arbitration clause. But that arbitration clause may be a narrow clause. You may say, I only want to refer A, B, C, D disputes to arbitration. Others are accepted matters. For instance, in Hyundai, Scott and Avery, I only wish to refer the issue of quantum. I don't wish to issue you to refer the issue of liability. Or, my lord, in a standard form construction contract, I don't want to refer issues where the engineer role is final.
In other words, the scope of the arbitration.
The scope of the arbitration. So that was Hyundai.
Separability.
That is, I am obliged. Separability. So, my lord, that issue is different from the issue as to whether the arbitration clause is valid or not. I.e., arbitration clause is legal or not. I.e., is there a bar under law, say, rent control or family, which is subject matter arbitration. These are two separate and distinct issues. My lord, that is also made clear in 34 2A2 and 2A4, which is why I had shown these provisions. They are two separate provisions. This is where the problem arises. 34 2A2, arbitration agreement is not valid under the law, which is in force. An arbitration agreement between me and my learned friend on my lord, family matters is invalid, void. So, my lord, that is 2. Then 4 is arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission or contains matters beyond the scope. So, my lord, this is a different. This is covering accepted matters. They are two different provisions. Now, my lord, unfortunately, in Hyundai, what happened is, my lord, that now in this light, your lordship will see Hyundai and I'll come back to the my lord, those or my lord, let me show how the
Why don't you take us through this Drolia?
Drolia, my lord,
Which are wrongly decided accordingly.
Right. My lord,
So we'll know.
Right. My lord, Drolia, my lord.
Paragraph.
But may I do this in reverse, my lord? I'll show Justice Ramana first.
Okay.
Normally, my lord, we see the first judgment first, but I just want to show that first to show, my lord, what has been said. Only few paragraphs. Only for this purpose of, my lord, stamping, not for, my lord, generally.
Yeah. Which paragraph?
My lord, please come. It starts at 156.
It's only supplementing, not descending, it's supplementing.
It's supplementing, but my lord, I will show paragraphs which collide, my lord. And that's where the outcome is the same. The result is the same. The reasoning is a little, my lord, this way, that way.
At logarithms with you.
Slightly, there is, my lord, there is an issue. Your lordship will see it. If I can show it, I'll show it. My lord, the judgment begins at page 156.
Can you come to the paragraph which you say?
My lord, the paragraph, I'll come to, my lord, where the judgment of Hyundai is concerned.
Which paragraph?
My lord, 201 to 203.
220.
201-203, page 184.
Yeah.
Well, there are some 7-8 other paragraphs I can show. No? 201 is Duro Felguera. 202 is Oriental Insurance versus Narbhiram. Following the decision in Vulcan, Vulcan is the Scott and Avery judgment under the old.
This is Ramana supplementing judgment.
Supplementary judgment at page 184.
180.
182.
Only referring to those judgments.
Right, very interesting. I'll just read it.
But why don't you take us to the exact paragraph where this is makes a particular point?
My lord, please see 203 last sentence. Very interesting sentence, my lord.
Restricted to the facts and sentences.
Yes, my lord, because he can't overrule it because it's 3 judges, my lord. So, may I just, my lord, run your lordship through the judgment, 5-6 pages, so that your lordship gets the full. It won't take very long, my lord. I'll just show the.
What we talk about? What is it that this is Ramana say? Which is at logarithm with what the.
My lord, one is this portion. One is this portion. More importantly, my lord, the conclusion at 244, 237 and 244 is inconsistent with para 146. So, my lord, 146, 147 is the conclusions of the first judgment, and 237 and 244 are the conclusions of the supplementary judgment.
244.
244. 237 and 244, 5.
Read that.
In Mayavati, 244, 5 valid. The court should refer the matter if the validity of the arbitration cannot be determined, laid down above. When in doubt, do refer, no problem. The scope of the court to examine the prima facie validity of the arbitration includes only whether the arbitration is in writing or whether the arbitration was contained in exchange of letter, communication, etc., whether the core contractual ingredients qua the arbitration agreement were fulfilled, on rare cases where the subject matter disputes is arbitrable. This is how we understand it. And I respectfully say correctly. Now please read, my lord,
You are referring to 237.4.
4, which is reflected in 244.5.
No, we are asking you.
Yes.
You are saying this is correct.
My lord, it should not be disturbed now. My lord, this is a view which has been taken. My lord,
No. What we are asking is something different.
Yes. This, my lord,
for the purpose of section 11, is it for the purpose?
It's for the purpose of 11.
Can we read it on rare occasion?
My lord, that your lordships have left that window, my lord. Our reference will become much larger if we go into that aspect.
No, this is after 6A.
6A.
And after the overruling of SPD, whether this can be.
My lord, I would have a problem with it, but my lord, this is.
Therefore, as
yes.
Michael,
my lord,
what is your stand? Your stand is that this is right, wrong.
My lord, I would say that.
I'd like to know your views.
My lord, my view is that this rare occasion should not be given because rare occasions become.
I mean, what is the question of rare occasion when the legislature says existence? On rare occasion, whether the subject matter dispute is arbitrable.
My lord, say it is patently void, as an example. So, my lord, subject matter is.
Arbitrability is different. I mean, unless you confine it to the
2-3.
2-3.
2-3, my lord. It is subject matter of dispute. He makes this clear earlier.
Okay.
I'll show that, my lord.
It is understood in that sense.
It is understood by him in that sense. By him in that sense, not in the other bench.
Then it's okay.
It is understood in that sense If your
Supposing a landlord-tenant relationship.
landlord, and my lord, he
Comes to
restricts
11.
he restricts it only to subject matter arbitrability, and that your lordships will find
Maybe not arbitrability in the other sense.
not arbitrability in the other sense.
If it's understood in that sense, fine. So now where is the problem now?
One of the problem is in the other judgment.
244.
No, in the other judgment. There is no problem in this judgment.
So you are saying this is.
I am saying, my lord, yes, my lord,
Understood in 2.3.
yes, understood in 2.3.
Okay.
Fine.
Now which paragraph of Dolia you want to see?
My lord, I want your lordships to see 146, 147,
146
6 and 147, which was,
doubted by the three judges bench.
which is doubted.
That is-
And my lord, to understand where that comes from, the basis of 146, 147
Yeah.
is 113, 114 and 115. So to understand 146, 147, the reasoning earlier to that, where Gadwade is specifically considered by the first judgment, is at
113.
113, 114 and 115. So Gadwade, Narbhiram and Hyundai.
Straight away, let's go to 113.
Right. Now 130, my lord. Or 113, Gadwade is quoted. That is page 130. Your lordships have come to page 130.
Yeah.
So 113, my lord, it is a quote of Gadwade. It's not it's the sequence. Then, my lord, 114. In Narbhiram Power versus Steel, three-judge bench decided civil appeal arising from application under 11.6 Insurance Act, primarily relying upon decision of so-and-so, held disputes not arbitrable in terms of the arbitration clause, as the insurer had disputed and not accepted liability. Arbitration clause applies only if there is a dispute pertaining to quantum. Well, Lord, this is the distinction I made. This decision, though dated 2/5/18, did not refer to 11.6a and interpret the same. So, my lord, there are decisions, and the reason is, my lord, because the notice was prior to, in fact, the Madras High Court from which it came, the proceedings had started before. So, my lord, 11.6 not noticed. So, the judge records, my lord, that, so it doesn't really take the matter. Decision and so, similar arbitration clause. However, in this case, reference was made to 11.6a. Therefore, clear that on two occasions in Narbhiram and Hyundai, a three-judge bench of this court affirmatively in clear terms held that the question of non-arbitrability, this is now the wider phrase of non-arbitrability, relating to the inquiry whether the dispute was governed by the arbitration clause, can be examined by the courts at the reference stage and may not be left unanswered to be examined. So, my lord, now by this paragraph, what is being suggested is that at a section 11 stage, your lordships will have to interpret the scope of the arbitration clause and decide whether or not there are accepted matters. This was not even the Boghara view. This was not even the Boghara view. The Boghara view, category 3, left accepted matters to be decided by the arbitrator. So, my lord, both Narbhiram, of course, there's no reasoning really, but Hyundai, I will show the reasoning. They couch an issue, make it an issue of arbitrability and say, now you decide. So, my lord, there's a problem with Hyundai, which is why Justice Ramana says it has to be limited to the facts and circumstances, facts of the case. These are decisions of three-judge benches quoted with affirmation Garwal. So, my lord, this is the 3 paragraphs, and the then various books are quoted. My lord, then your lordship straight away go to 146 and 147. 146 at page 149. We now proceed to examine the question whether the word existence in section 11 merely refers to contract formation, whether there is an arbitration agreement, and excludes the question of enforcement validity, and therefore falls outside the jurisdiction of the court at the referral stage. On jurisprudentially and textualism, it is possible to differentiate between existence of an arbitration agreement and validity of an arbitration agreement, such interpretation can draw support from plain meaning. So and so, however, equally possible jurisprudentially on context should hold that an agreement has no existence if it is not enforceable. Existence of an arbitration presupposes a valid agreement which would be enforced by relegating parties. Legalistic plain meaning contrary. A reasonable and just interpretation existence requires understanding context, purpose, relevant, binding, enforceable agreement. Agreement has no meaning unless parties can be compelled. Party cannot sue and claim rights. Thus, there are good reasons to hold that an arbitration agreement exists only when it is valid legal. Avoid an unenforceable understanding, no agreement. So, my lord, there are there's a little bit of confusion in this paragraph. My lord, existence, my lord, existence and contract formation. That is what Justice Ramana says in the paragraph 237 and 244. So, my lord, yes, you have to look at existence. Yes, you have to look at contract formation, but that's about it. My lord, validity, he says, is a question of enforcement. But my lord, validity is valid. A valid contract enforcement is a stage subsequent to validity. A contract may be valid, but yet, my lord, not be, my lord. And the learned judge also recognizes that it is possible to differentiate between the two. So, my lord, 146, last sentence is all right, my lord. There are good reasons to hold an arbitration exists only when it is valid and legal. Avoid and unenforceable is no agreement. No problem. So, my lord, the reflection of this is at para 147, 1.
The last part of 146, enforceable in law, you're saying if it is not a void contract.
It's not a void contract.
Within contract can.
So, my lord, existence.
Not in terms of the Stamp Act.
Not in terms of Stamp Act.
Right.
Now, my lord, please see the sentence at 147.1 after Garwade is quoted. 29 is quoted. Existence or validity are intertwined. So far, so good. An arbitration agreement does not exist if it is illegal. That is also okay. Document is not.
What we can perhaps understand, Prakash,
Please.
Stamped agreement, it exists.
Exists.
It is not void.
It is valid.
It is not even voidable.
So it is valid. Existence is there.
So the only
validity is also there.
Only thing is, within the meaning of section 35, you want to enforce it through a court of law.
I'll come to 35 later. Yes. Evidentiary
power. Law, it remains suspended. Limbo.
Yes, you can continue with the transaction.
You can continue with
you can
goes through. You can't get the aid of the court
to assist you in enforcing your substantive rights and obligations.
33, 34, and then get it stamped.
Yes.
It remains eclipsed.
It's there, my lord. I mean my lord, there are colorful sentences that the Stamp Act does not impact the lifeblood of commerce. There are some sentences in that judgment your lordships had seen. Perhaps that can be.
Yeah.
So, my lord, the conclusion. My lord, ultimately, my lord, on a very practical note, my lord, I'm giving up, though, my lord, there is some element of confidentiality. It's actually very simple, my lord. The agreement comes to you as the arbitrator.
So you are reading 147.
147, one comment. Existence and validity are intertwined, no problem. An arbitration agreement do not exist if it is illegal, no problem. Or does not satisfy mandatory legal requirements. Does this cover Stamp Act? It's not a mandatory legal requirement which makes it void. Supposing, my lord, invalid agreement is no agreement. Fair enough. If it's invalid, it's not an agreement. Your lordship can expand existence to include validity. That much, my lord. One can have that.
Supposing tomorrow the law is amended and it is said that to be a valid arbitration agreement, it should not only be stamped, but it should also be registered. It's just extending the, just to understand it. And we have to read it placing it side by side with section 49, the effect of non-registration.
My lord,
Has to
yes.
examine.
My lord,
Tomorrow they say it should be registered, so that we need to have.
we need to know. My lord, then
What would happen then?
Then, my lord, then it would perhaps, my lord, void the agreement.
It would void.
It would void the agreement.
Void the agreement.
Then, my lord, I would then have to argue that existence is even narrower than validity. But for present purposes, my lord, that is not necessary. In fact, the English Stamp Act.
Well, why we said that it does not satisfy mandatory
Mandate
requirements.
Yes. So mandatory. Yes.
Imagine a future situation where registration is made mandatory, then it would not satisfy mandatory legal requirements.
It would be, in fact,
the law would perhaps be
contrary to public policy.
That requirement.
It would not be non-arbitrable. It would be contrary to public policy. It would be all sorts of things would arise. My lord, in fact, the judgment of Justice Lord Williams mentions certain provisions of the English Act which void it. My lord. If it is to be avoided, it is voided. Then, if that was our Stamp Act, then, my lord, all this would have.
What is the current English Stamp Act? Lord Williams is there.
My lord, current English Stamp Act, my lord,
Also
current
requires stamping.
is will require stamp. My learned friend has put it on records.
Put the Stamp Act of
It will require stamp.
provisions of 6 countries, including UK, Singapore, Malaysia, who are the preferred destinations. Each of these Stamp Acts has the identical provision.
My lord, English Act is a little different. But, my lord, I will come to the Stamp Act and show, my lord, that in the vast majority of cases, actually, document does not require to be stamped, even though it has an arbitration clause. Even though a document has an arbitration clause, my lord, stamping is not required. I'll show that also. So, my lord, on a very practical note, if somebody comes to you and sitting as an arbitrator, and that document is placed before you, and it is said by the other side that it is unstamped, it takes, my lord, one hearing to decide it. You decide it, either one party pays, the other party pays. My lord, normally, I think this is a misconception. My lord, courts take the easy way out and impound it and send it to the collector. But 38 permits the court itself or the arbitrator himself to do that exercise. Straight away.
38 of
38(1)
Stamp Act.
Stamp Act specifically permits the court or arbitrator to do the exercise themselves. So I can sit and, my lord, that is what we are now doing. You look at the agreement, you look at the Stamp Act, you impound the document and you collect the duty with the 10% penalty and send it off. Finished. One hearing, it is over. Either one party pays, the party who wants the arbitration to go on will pay and recover it through the arbitration process. So, my lord, there is really no delay when it goes before the arbitrator. The delay is because the courts do not have, my lord, the time. It's simply a matter of time, my lord, and my lord, opportunity to decide it. Mr. Banerjee will come and say it is stampable. I will say Article 43 applies. He will say, no, Article 5 applies. You file counter, you file rejoinder, you file written submissions. All right, I now impound it, I send it off. Or I ask the registrar to do it. That also, your lordships, have not permitted. There are judgments where only the court has to do it. Only the court has to do it.
That's why you see the Indian Stamp Act. 33 read with 35.
Right.
And 30 and 40.
38, 40, 42.
Is a complete mechanism.
Is a complete. And then 61, which is the revision.
That is different. But still, that will not hamper the proceedings.
Well, Lord, today that's the only issue. Whether
should not hamper the proceedings.
That's the only
Once
issue.
the arbitrator decides and say this is the stamp which you have to pay, and send it to the collector. Collector may examine and whatever the deficiency is there can be taken care
Other
of.
side will challenge it. Well, normally, I can say this.
Insufficiency of the stamp is not a question to be examined.
In fact, my lord, the practical reality is this is now the first defense one is suggesting.
Correct.
Section 11
One
is
who is not interested for participating in
immediate
arbitration.
defense. Immediate defense.
The only with him is to put this question and leave the matter open.
And my
For
lord,
years together.
the
And
answer,
then 34.
answer is also not arbitration agreement. My lord, there's one other problem. If your lordship is 33.2, the other
Sorry.
33.2 is very interesting. My lord, we play it out. Supposing this document is placed before me, the under 33.2, I can't examine only the arbitration agreement. I will have to examine the entire instrument. I will have to extract the entire duty for the entire instrument, which will necessarily make me go into the substantive rights of the parties. Is this an agreement to sell? Is it an agreement of, my lord, of development agreement? Then I will have to forget, my lord, it's not a question of 8 annas anymore. It's not a question of, it is not a question of 5 rupees anymore. It is then you go to the substance. So, my lord, whether the 33.2 examination of the substance is something that was contemplated in 11.6. 11.6 examination is existence of arbitration agreement. But 33.2 requires you to examine the entire document.
The instrument itself.
Instrument. And you go beyond the arbitration agreement. 33.2.
That's one thing. The contract which is executed to the parties does not contain the clause of arbitration. But they say one clause, there are general rules applicable to the parties as we are transacting every time, running business going on.
Incorporation.
Like, that will apply. And that general rules have a clause of arbitration.
Correct.
Now, but the contract which
Doesn't have it.
that it does not contain.
Right.
What will this situation do?
But then the instrument before you, if 33.2 is to be applied, then you will have to stamp the substantive agreement.
Oh, that's one thing. We're talking about 6A.
6A, my lord, then you will say that the arbitration agreement exists by incorporation. Incorporation.
By incorporation.
And then refer it to arbitration. That's, my lord, that MR engineering, there is a series of judgments there.
Then also theory of stamp will come.
Then also theory of stamp will come. But then stamp of the main agreement. But that's the problem. No? The problem is that in the process, existence becomes existence of arbitration agreement, existence of the entire agreement, existence of substantive rights, stamping of substantive rights, duly stamped, how much money will you have to pay, then who will have to pay, how much is the penalty, then, my lord, the hole in the dike of the dam, your lordship knows the
The portions which are doubted are paragraph 146 and
147.
7 consists of many.
Many. My lord, I am showing the paragraphs which are problematic.
So which are those paragraphs?
147.1.
Yeah.
Then, my lord, effectively, my lord, 147.10.
10.
10. Others, my lord, it can, my lord, lordships may not, judicial, this, that, my lord.
So we need to be concerned with that.
There are some, my lord.
So 147.1 and 147.10.
And 11.
11, my lord, balances the forum and then knock out meritless
Privilege
litigation.
and all that.
My lord, then your lordships will have to go to 11.6 and my lord, then one will have to argue 11.6 at the
Different
pristine level, and then, my lord, we'll go through all of this. And my lord, I have actually done that exercise in the note. I have picked out every paragraph in the note.
Who is the 147.10? Why are you saying?
In addition to Garwari ropes, this court in Nabiram and Hyundai, both decisions of 3 judges, and Hyundai has rejected the application for reference in the insurance contracts, holding that the claim was beyond and not covered by the arbitration agreement. Court felt that the legal position beyond doubt scope was fully covered by dictum and Vulcan. So, my lord,
This is just a reference to what was actually done by the court. What is that view?
my lord, it in a sense, my lord, approves at 113 because, my lord, 147.10 is the conclusion to 113 to 115. The judge relies, my lord, on 115.
If it is a factual narration,
If it's a factual narration, my lord,
Capturing what had been done by the earlier case, in the earlier cases.
Your lordships?
The problem lies with those cases, not with the,
no, that has been
chronology-
made a basis for Garware.
Huh?
My lord, Hyundai is one of the reasons supporting Garware.
True, but what Dolia has nothing to do with it. It's just saying it has been done like that.
My lord, 113,
So
that your lordships can my lord, say that. But
which is we are just saying that perhaps the only paragraph is 146.
146, my lord, and my lord, 11.
So may I just submit one? In the Ellen Global judgment,
Yeah.
what is the copy that I have is for the judgment of the court, not the SCC one.
Yeah.
It is 6.112. We doubt the correctness of the view taken in para 92 of the three-judge bench in Vegetative. Now, para 92, if we read it, it is only para number 146 and 147.1.
That's it.
0.1 only.
10 will not come in.
That will not.
10 will not come in because 10 is
10.
just a chronicling.
Not very, my lord, it's a chronology, but it's yes.
Match it word by word. It starts at 1.
That's right. We have to only
147.1 I have also shown you, lordship. The question here is, and this is, my lord, essentially approving Garware, and 146 is, my lord, to the extent that, my lord, there are some comments regarding existence.
So this is substantially what more you have to say? We just wanted to.
My lord, I only have to deal with the 40 Act. I'm not showing NN Global.
Which act?
1940 Stamp Act, my lord.
Go ahead.
And my lord, the question of admissibility and acting.
Act.
This is it.
Let's say.
Because, my lord, thereafter there is NN Global. I am not reading NN Global. All those arguments, my lord,
You refer to 92, paragraph 92.
my lord, NN Global paragraph, there are.
No, not
No.
Global. Dolia.
My lord, NN Global.
147.1.
Correct. 92.
Which is equal to 92 in the judgment. Because
No, I've got 146 and 147.
147.1.
No, one kahan hai, sir.
What?
Right? SCC seems to suggest something.
One, it starts here. 147.1. Huh.
She will give me one second.
Yeah.
Between the SCC copy
Oh.
and the reported judgment, there seems to be some slight.
Got the SCC with us.
I have got the SCC copy, my lord,
You got this.
which only mentions 146 and 147. But what my learned friend says is that these are numbers which have been substituted by SCC, and actually the reference is only to 147.1. I'll check it up.
We are having a
147.1 is what is really at.
Yes. That is clearly.
147.10 is not there.
In fact, my lord, I will go one step further and say, my lord, at least 10, 15 years ago, just by way of aside, 2 minutes a day, 10, 15 years ago, we were, maybe 20 years ago, we were prohibited from citing any journal other than SCR.
That's right.
And if your lordships insist on that, then this problem will, and now that your lordships have put it on the net ESCR, everything is there. It's the same scan. So, my lord, if the court now insists, then we will all fall in line. Then this problem will not arise. Reported judgments.
There was a time this court was not accepting Xerox copies.
Yes.
Now everybody is asking Xerox copies because it's more convenient.
But, my lord, SCR, ESCR.
More convenient.
But certainly, my lord, there is some sanctity to it. ILR and SCR.
We are
courts
having
used to
issues
insist.
about the editorial notes.
Yes.
So
Judges used to settle it.
the Supreme Court is taking the initiative to have the editorial notes also prepared more or less simultaneously. So ESCR is going to be at the same space as the other journals.
It had almost caught up, my lord. It had almost caught up few years ago. But until the court actually pressurizes the bar to comply, we find SEC or something else much, my lord.
Today you are giving us a reason to enforce that.
My lord, this seems to
I
be
mean,
the
this example.
This example is there.
This is also, you know, the Indian Global, the judgment, which what we got has very separate paragraph numbers.
The paragraph numbering is different.
Has a different
Paragraph.
Other problem is earlier it was not the practice for judges to number the paragraphs. It used to be a,
Now we are giving indexing also.
now we are giving index.
So, my lord,
It used to be flowing text.
my lord, all that remains is 1940 Act and the Stamp Act. Issue. That's all that remains. I just and then I'll not conclude. I just read the last 2 pages after that. But please, first, I'm not going to take too much time on this. We've already gone back and forth on the Stamp Act. My lord, first, if your lordship sees what happened at the 1940 Act. This also I won't take too much time on. I'll just show us. And then, Manoj, what is my submission on the Stamp Act? This is a compilation on the stamping of arbitration agreement under the 1940 Act. This was a different regime. Manoj, what I have done is I have put the first edition of Justice Bachawat's book on arbitration. As your lordships would know, Justice R.S. Bachawat was probably one of the finest arbitration judges, apart from, my lord, whatever else he did. He was one of the finest arbitration judges, at least, my lords, we have seen. And post-retirement, he wrote this, and I put the first edition because this was all essentially authored by him. And it was authored in a very different style from what now the Bachawat on arbitration is a very different creature, but he wrote it in a chapter form. So I have just culled out 2 pages of that with the judgments. I'll just, my lord, may just come to page 2 of this compilation. Stamp duty on arbitration act. An agreement to refer a dispute to arbitration is chargeable to stamp duty. Well, there are 7 or 8 judgments. All are footnoted. All the judgments are annexed in this compilation. That's how it has been made. Page 2. An agreement to refer a dispute to arbitration is chargeable to stamp duty under Article 5 of Schedule 1 of the Stamp Act. This is why I was having little difficulty arguing to the contrary. But, my lord, these are all, of course, my lord, High Court judgments which construe the Stamp Act. This is a judgment of Calcutta High Court. I'm not going to read it. My lord, please see the next proposition. And it will have immense relevance to the present case. An arbitration agreement contained in bought and sold notes relating to sale of goods is chargeable under Article 43 and not Section 5C. It should be Article 5C of the Stamp Act. And, my lord, this judgment starts at page 13. My lord, para 3, if your lordship sees.
So, Bannerty, if you just come back to page 4.
Page 4.
That's part of
Yes.
There is reference made to a judgment of this court. I don't know whether it will throw any light. It refers to a case where the impossibility of referring it back to the arbitrator. You say the arbitrator is unto official making on the making award, it is no power to carry out such a direction. That is to rewrite on stamp paper that was reported in 1962, supplementary 1 SCR corresponding to AR 62 Supreme Court, 551. We may, because the judgment of this court, we should have a look at it.
My lord, this is a.
Just take AR 62 Supreme
Yes, no, I'll just cite that. But this is
551.
This is at the stage of award.
That's right.
This is at the stage of.
Because this court is spoken, we should have a.
Yes. My lord, we'll just get them. Well, in the meanwhile, I'll just run through these other 6-7 judgments.
Yes, yes.
So that, my lord, if your lordship sees footnote 17, it refers to Bombay Company, which is at page 2. Arbitration agreement contained in bought on sale notes relating to sale goods is chargeable under 43 and not so and so of the Stamp Act. Now, my lord, please come to that judgment. It starts at page 13 and it comes to page 14. 14, somewhere, my lord, paragraph 3. First, with regard to the question of stamp, and I'll explain what is the significance of this in our case. The same objection is taken in so and so. Learned judge stated no way out, difficulty, but it is the only objection, thought that the court could remedy. Now, the contract in this case, as in that, is comprised in bought and sold notes, each signed by the brokers and stamped under Article 43 of Schedule 1 to the Stamp Act with a stamp of 2 annas. This contract contains a number of printed clauses or conditions, the last of which, clause 12, constitutes a submission to arbitration. This is a live example. The petitioner's counsel made some attempt to argue real contract refers contained in subsequent letters with view to applying the ruling of Bombay High Court in the case of Gangaram Kushobai Rangole. I have annexed it, but this was clearly not the case. In my opinion, however, the agreement to refer any dispute whatsoever arising out of the contract to arbitration is part of the contract itself and not a distinct matter within the meaning of section 5 of the Stamp Act. If this be so, the whole contract clearly falls under the exemption clause A to Article 5, being an agreement or memorandum of agreement for relating to the sale of goods or merchandise. Only exception to that exemption, contract is also Y note, chargeable under 43. Contract contained in such notes are duly stamped. This view of the matter does not appear to have been before the mind of the learned judge. So, my lord, here, what does the judge do? The judge takes the document, the entirety of the instrument, he reads the arbitration, he reads the Stamp Act, he goes to Article 43, he goes to Article 5, he goes to the exemption. My lord, will this be permissible in 11.6 today? That's the question, my lord. In 33.2 is the 33.2, my lord, this is the exercise he will have to carry out.
Yeah.
This is the exercise which was carried out under the old law, my lord. But will it be permissible today? Will you want this court today or any court today to look at the instrument as a whole? My lord, there is a...
Possibly was in the 1899.
Right, 89. My lord, the proposition is this. The object is to restrict to examination of the arbitration agreement. My lord, I go one step further. Your lordship may say it is to restrict to the examination of the stamping of the agreement. My lord, I may have a problem with that. But in doing that, you will necessarily, because, my lord, I have conceded that it is one instrument. My lord, we are not going on the theory of two contracts, but there's a flip side to it. The flip side is that if it is one instrument under the Stamp Act, then the appointing authority will have to look at that document. That's the normal case, my lord, which comes. It's always the contract with the arbitration clause at the end. Then he will have to look at the document. My lord, then does he confine himself to the arbitration agreement? Forget the word existence. He is not confining himself to the arbitration under 33.2. He cannot confine himself. He has to look at the full document. He has to give the duty on the full document. He has to go into the Stamp Act. So, my lord, I submit that because of 11.6a today, 33.2 cannot be operated as it was here. So, my lord, this example shows what the problem was. And, my lord, how this was. And, my lord, in fact, one other very interesting thing. All the judgments are post-award stage. There is no judgment I could find which was at the initial stage. Even then, my lord, and all the judgments, though this book was written in 1983, just a few years after his retirement, many years after his retirement, just 2-3 years after his death, all the cases your lordship will see 1912, 1908, 18s. Because, my lord, then there was an issue of separate arbitration agreements. Today, 99.9% of the cases, the agreement is the one which has all the substance and all the clauses. My lord, it is very rare to write a one-page letter saying, I refer my disputes to arbitration. So, my lord, today, if we are to do this and thrust it upon the 11th judge, he will have to do this also. So, my lord, this is where the problem is. And my lord, therefore, I submit that because of this circumscribed, my lord, jurisdiction, this is not a burden which we are to give. My lord, I show one more case. Please come to page 3. Please come to page 3, third paragraph. Another example, practical example. An agreement for sale of goods which is exempt from stamp duty does not require stamp, though it contains provisions of warehousing, insurance, and reference to arbitration. Because sale of goods, the substantive my lord, agreement is exempt. My lord, Mr. Datar was mentioning examples where the substantive agreement is exempt in backward areas. Are we going to request the appointing authority to go into this? Or are we going to leave it to the arbitrator to solve the problem? So, my lord, these are concrete examples of cases where previously the courts used to go into it. Now the legislative intention is not to go into it. My lord, these are 6, 7 cases. I've just put the cases there. Now, my lord, the last issue, but by no means the least issue. What is the correct way of reading 33 and 35? 2 answers. Because that's the elephant in the room, my lord. 2 answers. My lord, one I had argued yesterday, I'll give a note. My lord, the submission is, you give the note. Well, this I've already argued, I'm just putting this one in. My lord, there is another way of looking at it. There are 2 phrases used, assuming 33 and 35 applies. My lord, my first case is that 33 and 35 don't apply. They don't apply at the stage of appointment, but they do apply at the stage of
16.
Well, not even before 16. It's the first thing they raise. Well, not you don't wait for 16. Good morning, I object. Well, that's at least that is what happened in my case. This is not stamped. So you sort it out at the beginning. You don't even wait for a 16 of pleadings. So, my lord, that is one way of looking at it. My lord, assuming I am wrong, this is not an argument your lordships wish to accept. It is an alternative argument. My lord, the alternative argument is that section 33 and 35 give rise to an evidentiary bar. Now, the answer which will be coming from the bench is, it is not only an evidentiary bar, but it is not only admission to evidence, but acted upon. I'll take these 2 separately. My lord, admission to evidence under the CPC, as your lordships know, my lord, comes at a little later stage. Pleadings are completed. It only comes at the settlement of issues. Order 13 only comes at the 12-13 comes when issues are settled. And impounding finds place in order 13 of the CPC. At that stage. So, my lord, if we take a parallel, though it's not really fair to take a parallel, you have a section 21 notice, you start the arbitration and you complete pleadings, then you come to evidence stage, then, my lord, at the evidence stage, you have admission denial, admitting documents, the arbitrator, my lord, may step in there. So, he may step in earlier because of section 17 relief or whatever it is. But assuming, my lord, that all this is not correct and I have to meet both conditions of admission and acting upon, my lord, there is one article I want to show which explains, my lord, this very nicely, and I'll just show that article. It's already on there. Compilation part formula.
Compilation
4. There has been a lot of writing on this way, that way, the other, but some of the articles are very interesting. One gets very interesting ideas. That's why I put out 6, 7 of them just to see, what their ideas are.
Balaji, guide us on this issue also. Suppose we agree with you that in the guise of this existence of an agreement, you can't make the scope so vital.
Right.
And start examining the stamp also, whether it's stamped, unstamped, insufficiently stamped.
Correct.
These are not the issue.
Correct.
All right, we proceed. Now we appoint the arbitrator.
Right.
Now our job is over. The court's job is over.
Right.
Now we go to the arbitrator.
Correct.
The man who is not interested to participate in arbitration, the first recourse would be
Raise the point. No problem.
No, what we want to know from you. He can't press aside by saying that you go and make an objection there and let the matter be dumped over there. No. We want the smooth functioning so that the arbitration must be concluded within the time bound with whatever the objections the parties interested available under the law.
Correct.
Within the time framework.
Correct.
So to have the time framework to continue and the parties, regardless of their objections, which is validly to be raised, available, can also be meted out.
Correct.
Otherwise, what will happen? If we accept your view, at least we have shifted our burden.
Correct.
Now sent to the arbitrator.
Right.
Now, in the arbitrator, the people raise an objection and start.
My lord, your
Want
lordship.
that mechanism to
Yes,
go ahead.
I will suggest
That it may conclude within the time bound in terms of the legislative wisdom.
some guidelines your lordships can.
Otherwise, what will happen? We are just putting a. Now we are running into pages and pages and pages. Ultimately, we are not doing justice to the man who is before the court.
Right, my lord.
Ultimately, we want that it must go to a level where the person are expecting from granting relief by the courts.
Correct. That's the, my
And
lord,
the
primary.
ground reality has to be kept in mind.
Your lordships, my lord, I can suggest some my lord,
Some-
guidelines
so
as
that
well. My lord,
Should
practically,
not stuck there.
it should not be stuck there. In fact, my lord, there are three possibilities. One is once the party realizes that this is not really a good defense in an 11th stage, he may just not even raise it. That's one possibility. Even then, my lord, the arbitrators is required under law to look at it. Alternatively, one party will raise it, the other party will pay to buy peace and get on with it. My lord, that is what is usually happening, and then go through the procedure and recover it. So there are, my lord, 3-4 possible. I'll formulate, my lord, your lordship accepts it, I'll formulate some possible guidelines.
Better for guidance.
Because my lord, one advantage of arbitrators.
Working before the arbitrators also.
One advantage of arbitrators is he or she can decide it themselves. That power is there with the court also.
33, you can do it and send to collector thereafter.
My lord, may just see 38 one end.
38,
1 versus
38-1.
38 2.
that's correct.
You can actually
We
collect the duty, collect the
and send to
penalty,
collector.
send it to the collector, get a certificate, and send that person off to challenge or do whatever he wants to.
What
That
happens
proceed.
if the arbitrator doesn't have any, is it necessary that he has judicial experience, a technical person
Technical person, my lord,
can also be an arbitrator,
can also be an
sole arbitrator?
sole arbitrator.
So he may not have any, judicial kind of training or understanding of.
That happens, my lord. We have to face that issue, my lord.
No, when it comes to stamp duty, we're talking about.
He is empowered, my lord, by consent of party.
Then forward we know that.
My lord, then there will be many more problems
Because
other
he's
than
a chief
stamp
engineer.
duty. My lord, that will be the least of the
Apparently,
problems.
he's a chief engineer.
Sorry, my lord?
He's a chief engineer. Technical man.
An engineer.
An engineer.
Engineer.
And he's an arbitrator. He doesn't know so much of intricacies and ICTs of this problem.
Right.
Now, if he raise an objection there,
We'll send it off.
now he put his hands up by what to do.
Impound and send off.
That's correct. So he must have some background to know about it. And what is my role to play such an objection not being raised?
One of the problems that may arise is it is an order of a court which sends a document to a collector and says, you please assess within 45 days in view of Garawale, give it back to the court. Suppose this is done by the arbitrator, an individual. I can be an arbitrator. I can be an arbitrator. I can be appointed an arbitrator. I write a letter to the collector. Please evaluate, send it back within 45 days in view of Garawale. Collector, I'm an individual. I don't have any statutory backing in the sense
There
that
is-
it's an interim order under 17(2), which is deemed to be a decree. One, the award is deemed to be a decree. So by legal fiction, his orders are enforceable.
You want to say, you are asking 45 days, even 145 days, the document is not returned.
My lord,
In
even
this
with
case-
45.
No, I'll tell you this. In NN Global, the letter came from the registry. I submitted, it was sent and adjudicated, amount paid. That's, it was done. And the lordships have put a very pointed question. Ordinary person can be appointed as arbitrator. How will he look at the Stamp Act? And what will he, because 27 requires.
Certain things are to be presupposed. If you are an arbitrator, You are presupposed to know. You either don't accept.
Because
You are presupposed on this.
suppose in a family setting, two branches of the family, so the eldest member of the family is the arbitrator, whatever he decides, final. Then,
They are
what
conciliator.
is the sanctity of an order?
They are conciliator. They are conciliator.
We'll suggest some guidelines to
The problem
deal with this.
enforceability. Because the court sending a document has the power of the
They cannot
authority
be
of the court.
defined. Suggest something so that
We'll suggest. My lord, may just see 3 pages of this, and I'll, my lord, conclude my submissions, and I'll just, my lord, make my points. This is an article at 102 by an advocate in the Bombay High Court. My lord, I had some discussion with him, and he sent me this article, my lord.
where do we find it?
The volume 4, my lord,
See,
page 102.
so that you have to invent somebody.
My lord, this is one view, but I believe, my lord, the discussion on section 35 between pages 102 and 104 would be, my lord, relevant. He explains, my lord, the breakup of section 35 and what you mean by acted upon, what you mean by persons authorized to see. And, my lord, it's a very interesting analysis. He relies on the Allahabad High Court Bitten BB. I have put a copy of that in, and that has been approved by my lords in Hindustan. So, my lord, this analysis at one
Judgment on acted upon.
this is, my lord, he analyzes acted upon, and, my lord, that
You're looking at a
Any judgment. Any judgment.
my lord, Bitten BB, which is the full bench judgment of the Allahabad High Court, my lord, explains when these, my lord, there is no judgment specifically I could find, my learned friend, on
No judgment.
No, these 3 terms to acted
acted upon, my lord, then I think it is registered, something else, my lord. There are three words, my lord.
Was a statement of objects
My lord, we have the of the Stamp Act, my lord, there is only act to consolidate fiscal, my lord, that is discussed in it. But, my lord, this interplay of 33 and 35 has been dealt with by the Allahabad High Court in a full bench. We have put it in, and that full bench had Justice Raghubar Dayal, Justice Desai, and one other. Justice Desai was in the minority. The Supreme Court overrules the minority, which was really not required. By that time, Justice Raghubar Dayal had come to the Supreme Court, but was, of course, not on the bench. So the majority judgment in Bitten BB has been approved in Hindustan, my lord, Steel, which I had showed myself. These 2 pages are this gentleman's analysis of, my lord, Bitten BB and Hindustan Steel, where he says that the bar is an evidentiary bar, and the acting upon, so far as judicial, my lord, the section contemplates 2 categories of people, 35 and 33. One category of people are like arbitrators, judges, who are authorized to take evidence.
We'll give you an example.
Authorized by.
This structure. See, supposing an unstamped document is allowed to come into evidence. So it can be.
Then no problem, no. 36.
No. We are just trying to
Yes.
give some meaning to the words acted upon.
Yes, ma'am.
So, assuming an unstamped document comes into evidence,
Correct.
can we possibly say, to go meaning into the words shall not be acted upon, that when the court finally adjudicates, writes a judgment,
Right.
decides a list,
Correct.
it will not enforce that unstamped.
No, this was the exact point in Bitten BB which has been approved. This was the exact argument which Justice Desai accepted. He said that there is a dual qualification. The majority said no. So far as judicial officers is concerned, the bar is evidentiary. Acted upon is the second stage. If you clear the evidentiary bar, it would be, and 35 was not interpreted in isolation. It was interpreted along with 36. Because 36 does not have this acted upon. So, Your Lordship will just read these 2 pages. It's there.
Yes.
So, my Lord, in conclusion, my Lord, my submissions are in the last page. I'll just show. And my Lord, I've taken a lot of Your Lordship's time. My Lord. Please see the last.
But you are the amicus. So
My
we
Lord,
should be grateful to you.
My Lord,
The court should acknowledge the work that you have
My Lord,
done.
I must say, in all fairness, my Lord, it is certainly not my individual effort, my Lord. I am merely the face. There are 3 gentlemen standing here who have contributed. Various other people, my Lord, have.
Team, because you have put
Yes.
so much work.
And all sorts of persons from all sorts of all walks of life have, my Lord, put in their ideas. 6:30 in the morning, Mr. Datar called me with something. So everybody, my Lord, is putting in there. Because, my Lord, ultimately, it's a matter of approach. Your Lordship, my Lord, the question, there are two my Lord, end results are possible. But I am advocating for one end result, my Lord, simply because this interpretation that you do this at the outset, my Lord, will defeat every thought of arbitration, my Lord, right through. So if this is the necessarily only conclusion, Your Lordships will go for it. But, my Lord, I think there is enough material to show that, and, my Lord, we have set it out, and nobody is going to get hurt. My Lord, the government of India or the government will not get hurt. They will get their money, my Lord. They will extract their pound of flesh just a little later. That's all, my Lord. It's a win-win. It's a perfect balance. The arbitration will go on. Government will get its money. My Lord, both statutes will work. The alternate is neither will the government get its money, nor will the arbitration go on. So, my Lord, those are my respectful submissions. Deeply obliged. Not really. Very good.
Convenience compilations.
You got 6 and 9.
Three. Just briefly introduced. My compilation 1 is the relevant provision of the Stamp Act, bringing the Stamp Act, Maharashtra Stamp Act, SMS and 3 judge-based judgments.
The problem is people never consult each other before the compilations are made available to the court. And there's so much of duplicacy. Because you can't get some material from other way around. Duplication is such.
Otherwise, you will
I correct, yeah, duplication. So much of duplication is there. Because we go to one convenience volume, then becomes second convenience volume, the same.
Convenience volume, common convenience volume.
Creating inconvenience.
What my learned brother was trying to hint at is indirectly,
That should use
in a graceful manner, that some time limit is what he is trying to say.
Better it is.
Isn't it?
Better it is. Because you understood one line of action is there.
No, but then of course you should have a full slate. You should hear it. Just we are not forcing anything, but that. Yes.
What's the first compilation has judgments of SMS, Nyanapatra, because that is referred. That one, a 3 judge-based judgment, which follows SMS, which has been overruled. Then another 3-page judgment in Dharma Ratnakar. Both of these judgments are not noted in the NN Global judgment. Both of them follow SMST.
There were 3 judges?
Yes, Manoj. That's why all the compilation is. My second compilation was convenience compilation 2 is restricted to few provisions of the Arbitration Act, as we have seen. And then judgments on legal fiction. Because the section 16 in my submission, as noted by Vidya earlier, is a case of a legal fiction. It is created for a very specific purpose. First, the purpose is set out, and then the fiction is created. The settled law is, it is to be restricted for the purpose for which it is created to the section. It cannot operate to any other section, much less to a different act altogether. That's my second. And I begin by Bengal immunity, 11 judges, 2 constitution-based judges. And then it also has 2 judgments dealing with statutory fictions created under Section 17(2) of the Arbitration Act, that is, in Amazon. And then Vedanta, again a statutory fiction under Section 36. The judge notes that these are legal fictions, limited, and then follows Bengal immunity, 11 judges, not to go beyond the fiction. It is my understanding, Millards, of the judgment in NN Global, para 6 and onwards, that this concept of a legal fiction has been stretched to mean that the arbitration agreement has is a document at all which is separate. It has a separate existence. So maybe the main agreement is not stamped. Still, it will not affect the validity. The separability will come to the rescue of the arbitration agreement. That is one. That is my understanding of NN Global, which in my submission is not correct. Then, Millards, my third convenience compilation, it is the entire Indian Stamp Act. It has 3 judgments of this court, 2 judgments of this court and 1 of the Privy Council as to how Indian Stamp Act was interpreted, 2 provisions. Then I have also, Millards, put in 1 judgment of the UK Supreme Court as to now how the concept of separability is being restricted for the purpose for which it was created. It is not a magic wand, which if you use would make all legal bars disappear. More so when it is created by a separate act. Then, Millards, I have pointed out in this volume, there are 6 stamp acts of different countries. Each have identical provisions imposing bar. Bar document must be impounded, would not be acted upon. Those are my basic volumes. Now, can I invite my Lord's attention to some provisions of the Stamp Act? My learned senior.
You are supporting Vegetative.
I am not supporting it. I am saying, Millards, my contention is very simple. SMST is the correct law. Does not require to be overruled. Garware is the correct law. Just because Garware was cited with approval in Vegetative, that did not make any difference according to me. And in NN Global, what was done was SMST overruled Garware because it is affirmed by a 3-judge bench, doubted, and then the reference comes to your lordships. If that be the reasoning of the reference words, what the learned court forgot was SMST by itself was followed by 2 3-judge bench judgments. Garware was followed by Vegetative, 3-judge bench. Therefore, the parity of reasoning that I will...
The other 3 judgments, 3 bench was not noticed.
No. And in fact, Zolia came in when this NN Global was closed for order.
Straight away shows those 3 judges bench.
Certainly.
Let us straight away go to that. Which are those?
Your lordships may have convenience compilation 1.
With the citation, if you don't.
It is 2011-14 SCC.
2011-14 SCC.
Page 66.
Was that brought to our notice? Government manager, did he bring it to our notice?
My lord, I brought it to your lordship's notice. The judgments do not consider 11.6a. These judgments are pre-11.6a.
That's
SMSP is 11 pre-11.
No, SMS, but
Even these judgments, my lord, do not consider, only Garware considers 11.6a. These judgments do not comment on 11.6a. They simply follow SMST. And my lord, I had also mentioned, your lordships will recollect, that these judgments arise from matters where pre-11.6a reference was made. Therefore, my lord, I had mentioned it, but I should have mentioned it more, my lord, forcefully.
It is Garware basically, which is 11.6a and the interplay as to whether 11.6a overrules the SMS principle. It says no. Now, may I just first show SMST judgment which was overruled. The lordships may straight away come to para 70 of the SMST and para 90. It notices that Registration Act Section 49 has a proviso which saves the document from being used for a collateral purpose. There is no
any purpose.
There is no such proviso in section 35 of the Stamp Act. Now, para 17, the second question, which is stamping, starts. What if an arbitration agreement is contained in an unregistered but compulsorily registrable instrument which is not duly stamped? Then it notices Indian Stamp Act, section 33 and 35. Then 19 is the discussion. Having regard to section 35 of the Stamp Act, unless the stamp duty and penalty due in respect of the instrument is paid, the court cannot act upon the instrument, which means that it cannot act upon the arbitration agreement also, which is a part of the agreement. Section 35 of the Stamp Act is distinct and different from section 49 of the Registration Act in regard to an unregistered document. Section 35 of the Stamp Act does not contain a proviso like section 49 of the Registration Act, permitting the instrument to be used to establish a collateral transaction. Then, these have para 20. The scheme for the appointment of arbitrators by the Chief Justice of the Guwahati High Court, 1996, requires an application under section 11 to be accompanied by the original arbitration agreement or a duly certified copy thereof. In fact, such a requirement is found in the scheme and rules of almost all the high courts. What if is produced is a certified copy of the agreement, contract, instrument containing the arbitration clause. It should disclose the stamp duty that has been paid on the original. Section 33 casts a duty upon every court, that is a person having by law authority to receive evidence, as also every arbitrator who is a person having by consent of parties authority to receive evidence, before whom an unregistered instrument chargeable with duty is produced, to examine the instrument in order to ascertain whether it is duly stamped. If the court comes to the conclusion that the instrument is not duly stamped, it has to impound the document and deal with it as per section 38 of the Stamp Act. Therefore, when a lease deed or any other instrument is relied upon as containing the arbitration agreement, the court should consider at the outset whether an objection in that behalf is raised or not, whether the instrument is properly stamped. If it comes to the conclusion that it is not properly stamped, it should be impounded and dealt with in the manner specified in section 38 of the Stamp Act. The court cannot act upon such a document or the arbitration clause contained therein. But if the deficit duty and penalty is paid in the manner set out in section 35 or 40 of the Stamp Act, the document can be acted upon or admitted in evidence. Notice the submission is in para 22 and I am relying on 22.2. If the document is found not to be duly stamped, section 35 of the Stamp Act bars the said document being acted upon. Consequently, even the arbitration clause cannot be acted upon. The court should then proceed to impound the document under section 33 of the Stamp Act and follow the procedure under section 35 and 38 of the Stamp Act. Then 22.4. Once the document is found to be duly stamped, the court should proceed to consider whether the document is compulsorily registrable. If the document is found not to be compulsorily registrable, the court can act upon the arbitration without any impediment. Now, Milos, this is not without noticing the principle of section 16 of the Arbitration Act. Please have para number 12 of the same judgment, SMST. So it is not as if the principle of separability was not noted. Para 12 of SMST. When a contract contains an arbitration agreement, it is a collateral term relating to the resolution of dispute, unrelated to the performance of the contract. It is as if it has two contracts, one with regard to substantive terms of the main contract and the other relating to the resolution of disputes have been rolled into one for the purpose of convenience. An arbitration clause, therefore, is an agreement independent of the other terms of the contract or the instrument. Noted. Resultantly, even if the contract or its performance is terminated or comes to an end on account of repudiation, frustration or breach of the contract, the arbitration agreement would survive for the purpose of resolution of disputes arising under or in connection with the contract. Then, para 14 quotes section 16. Now, just have a discussion at para 16. An arbitration agreement does not require registration under the Registration Act. Even if it is found as one of the clauses in a contract or instrument, it is an independent agreement to refer the parties to arbitration, which is independent of the main contract or instrument. Therefore, having regard to the proviso to section 49 of the Registration Act, led with section 16(1)(a), an arbitration agreement in an unregistered but compulsorily registrable document can be acted upon and enforced for the purpose of dispute resolution by arbitration. So the court is very conscious. You have a proviso in section 49 which permits it. You don't have a proviso in section 35, can't be done. It acts as a bar. And when can be it acted upon? On payment of duty. There's a procedure to it. Now, Millers, please have the next judgment in the compilation, which is Nana Thakkar, which is the only judgment on section 8, where the section 8 application was dismissed by the court. This is, I am reading page number 43, convenience compilation 1. The learned counsel for the petitioner places reliance on a decision of this court in SMST and submits that the second additional chief judge in his order dated so and so in the application made by the petitioner under section 8, having held that the lease deed is insufficiently stamped, ought to have impounded the said lease and followed the procedure prescribed in the section 35 and 39 of the Stamp Act. And if the document was found not to be duly stamped, should have given an opportunity to the petitioner to make up the deficient stamp duty and pay a penalty if directed by the collector. Having not followed the above procedure, the said court committed serious illegality in rejecting the petitioner's application under section 6. Now, Millers, please come straight to, and this notes SMST in para 5. These are para 6, 7. In the light of the above legal provision, when we look at the facts of the present case, we find that while pressing the application under section 8 of the Act, the petitioner did not show any inclination to pay the deficit stamp duty on the lease deed, nor expressed his desire that he was willing to pay the penalty as may be imposed by the collector. If the document was impounded and stamp duty payable thereon was determined, it is true that the consequences provided in the Stamp Act must follow when sufficient stamp duty has not been paid on an instrument, irrespective of the willingness of a party to the instrument to pay deficit stamp duty. But the procedure, now, this is a bit for your lordship's consideration. The procedure when the arbitration clause is contained in a document which is not registered, although compulsorily registrable and which is not duly stamped, as summed up by this court in SMST, shall not be applicable to the proceedings under section 8 of the Act, where the party making such application does not express his or her readiness and willingness to pay the deficit stamp duty and penalty. It is not the duty of the court to adjourn the suit indefinitely until the defect with reference to the stamp duty concerning the arbitration agreement is cured. Accordingly, the matter was dismissed. Therefore, the moment you file a section 8, you file a section 11, it is upon you to make the stamp duty deficit complete. Now, the 3-judge bench judgment notes, which is not noted, is at page 46, black hole, which follows SMST. Now, this is under the Karnataka Stamp Act, but provisions are identical. SMST is noted in para. In fact, you can have the discussion from para 8. This is a section 11 application being dealt with. At the outset, we think it appropriate to make it clear that we are not determining whether the agreement in question is a lease or license or an agreement simpliciter, as put forth by the learned counsel for the appellant. That is required to be dwelt upon and addressed by the High Court while deciding an application under section 11 of the Act. It is well settled in law that while dwelling upon the appointment of an arbitrator under section 11, regard being had to the nature of agreement referred to in section 7, the judge designated by the learned Chief Justice is obliged to consider the nature of the agreement and whether the document requires to be stamped or not, and if so, whether the stamp duty has been duly paid on the same. We are so stating in the instance case that there is a written instrument and there is a dispute as regards nature and character of the document. Therefore, in my respectful submission, only 3 things: nature of the agreement, whether it requires to be stamped or not, and whether requisite stamp duty has been paid or not.
Prior to 6A.
This is prior to 6. Now, SMST is noted thereafter, and then ultimately the matter is dismissed. The matter is then sent back to the High Court. That please, the High Court judge should determine what is the nature of the document. It notices SMST in para 9. That's all I want to point out. And 9 and 10. 10 minutes comes Garwade. Garwade, your lordships have seen in its my only submission would be para 19 in Garwade is the correct interpretation of law. Para 19 of Garwade takes in account, or para, in fact, this is the section 6A, 11.6A. the Lordships would just permit me, I will show it from the beginning. Please have page number 62 in the compilation, para number 3. What is the question formulated in Ramana?
Yeah.
The question is whether 11.6a, which has been introduced by way of the Arbitration and Consideration Amendment Act 2015, has removed the basis of this judgment, this is SMST, so that the stage at which the instrument is to be impounded is not by the judge hearing the Section 11 application, but by an arbitrator who is appointed under Section 11, as has been held by the Indian law. So this was the exact controversy on which we do argue. Section para number 4 notes the arguments that it can't be looked into relying on SMS. Then the provisions of the Arbitration Act, the Maharashtra Stamp Act, because this was a case under the Maharashtra Stamp Act, were required unnoticed. Just have para 14, Law Commission report. The reading of the Law Commission report together with the statement of objects and reasons shows that the Law Commission felt that the judgments in SBP and Bogara required a relook, as a result of which, so far as Section 11 is concerned, the Supreme Court, or as the case may be, the High Court, while considering any application under Section 11(4) to 6, is to confine itself to the examination of the existence of an arbitration agreement and leave all other preliminary issues to be decided by the arbitrator. The question is whether the decision in SMST has also been done away with the expression notwithstanding any judgment, decree, or order of the court contained in Section 11. Again, precise question. Then SMST is noted extensively. SBP is noted, then 19. It will be seen that neither in the statement of objects and reasons nor in the Law Commission report is there any mention of SMST. This is for the very good reason that the Supreme Court or the High Court, while deciding a Section 11 application, does not in any manner decide any preliminary question that arises between the parties. The Supreme Court or the High Court is only giving effect to the provisions of a mandatory enactment, which, no doubt, is to protect revenue. SMST has taken into account the mandatory provisions contained in the Stamp Act and held them applicable to judicial authorities, which would include the Supreme Court and the High Court acting under Section 11. A close look at Section 11.6a would show that when the Supreme Court or the High Court considers an application under Section 11(4) to 6 and comes across an arbitration clause in an agreement or conveyance which is unstamped, it is enjoined by the provisions of the Stamp Act to first impound the agreement or conveyance and see that the stamp duty or penalty, if any, is paid before the agreement as a whole can be acted upon. It is important to remember that Stamp Act applies to the agreement or conveyance as a whole. Therefore, it is not possible to bifurcate the arbitration clause contained in such agreement or conveyance so as to give it an independent existence, as has been contended by the respondent. The independent existence that could be given for very certain limited purpose on harmonious construction of the Registration Act and the 1996 Act has been referred to by Justice Ravindran and SMST when it comes to an unregistered agreement of conveyance. However, the Stamp Act contains no such provision as contained in Section 49 of the Registration Act has been held by the said judgment to apply to agreement of conveyance as a whole, which would include the arbitration clause contained therein. It is clear, therefore, that introduction of Section 11.6a does not in any manner deal with or get over the basis of the judgment in SMST, which continues to apply even after the amendment of Section 11.6a. This is what is now let's para 20. It is now looked from a slightly different angle, and it is in this context that the provisions of the Contract Act, Section 2, EFGH are noted, and the conclusion or the finding is at para 22. When an agreement clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. We have seen how, under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped.
So there is where Ms. Banerjee points out, the subtle nuance that to be not enforceable, it must be void.
Section 33.
You see the Contract Act.
Yes.
Enforceability is actually understood in the context of it being void. Or rather, unenforceability.
Yes, that is why
goes
my
to
respect
it being void.
it is qualified unless it is duly stamped and judgment. unless it is duly stamped. Your Lordship put it, it is sort of eclipsed. It is there. It is there. But till the time stamp duty is not paid, it is eclipsed. The moment you pay the stamp duty, the bar of the eclipse goes, it can be acted upon. It can be, it is admissible as evidence.
So it is not ab initio void.
No, no.
The agreement is valid.
Everything is valid. The transaction is good, but it is not enforceable till the time stamp duty is not paid. The moment the section itself says so, until the time stamp duty is paid. Just have a wording, just have a look at
So in a different sense, when you talk about enforceability, suppose you enter into an agreement, it is not stamped. Money is paid, services are rendered, parties fulfill their obligations up to a particular point, let us take, till actually they join issue, or at some point. What was the nature of the contract during the time it is actually utilized by both parties? Would you say it is not enforceable?
it is enforceable because the parties have acted upon it.
Acted upon.
On their own volition, they have acted upon it.
Therefore, can you say that it is not enforceable in that sense?
According to me, if you see the definition of in 2G of the contract,
As contrasted with the document which is actually void. Even there, of course, you can possibly say even transactions could take place between the parties, purporting to act under the aegis of a void contract. Voidable itself is a very, very large
it's very large.
where till you
Because
get
nothing
it.
prevents the party to enter into an oral contract. It's very simple. Oral contract, no stamp duty is required. Out of the Stamp Act. The problem comes when you start enforcing it. One party backs out. There is a problem in the
Arbitration
contract.
agreement requires an agreement in writing.
In writing.
So that difference is there.
That difference is. Let us examine this. The party comes to section, to make an application under section 8, 11 to do what? 9 to do what? And force the agreement. At 8, it says, sir, there is an arbitration agreement, no civil suit, it have to be sent to the arbitration. It is enforcing a term of the agreement, the instrument. Section 11, appointment of an arbitrator. The court, please look at the document, instrument, there's an arbitration clause, please appoint an arbitrator. That's acting upon.
Enforcing.
It's enforcing.
That's you.
You may do it on your own.
One thing you have to examine. Pre and post regime, 6A, one thing. A provision for arbitration is only opening a window for availing the remedial mechanism. It is nothing else
Nothing else.
from the contract. You are not tinkering with the contract. What are the transactions, the business contracts you entered into? This only provides you a mechanism other than what is being prescribed by law. That you have this additional mechanism also, if the parties undertake, can avail this remedial mechanism. So the question to you would be that enforceability in reference to what? Enforceability in reference to the contract is one thing. Enforceability with the nature of a mechanism to adopt to the parties in coming for arbitration is one thing. So the question is, that's why you are asking in 6A, it's only implementation. To what extent this, you see, implementation is section 16 also. Implementation you find in 16 also. Implementation you find in 6A also, 11.6A also. Now you have to examine as to what is the effect of implementation in 6A of section 11 and what is the implementation in section 16. 16 comes after the arbitrator take a call. 6A is up to the stage when the prima facie is to be examined. We are not going to go into the intricacies of it. So the question is, what is the effect of implementation in 6A and the same implementation of 16?
In fact, also section 8, because that's the first.
Section 8 also, correct? Section
8, 9, 11, 16. You all have to be.
Enforceability of commercial contract in reference to a transactions is one thing.
Right.
Enforceability of a remedial mechanism. What is enforceability? It's not to avail a remedy which we have agreed upon on an unstamped document.
Without 11 and 8.
Yes.
Put it.
Can come into existence. Supposing parties.
By consent. No section 11 is there.
Whatever, no 8, nothing is required.
Go to an arbitrator. It is appointed. But then the arbitrator will be.
Problem is only when you travel through 6A.
Exactly. In fact, say or 8.
8.
Or 8.
What will come, go, let the train move. Don't worry.
कुछ नहीं बोलना हाँ yours sorry
sort of what we've sort of kind of discussed is also, the whatever further you have to say,
Yes.
you say, and then Monday, we will have some kind of informal discussion and dictate the order on Tuesday. This is what we have, because we have to give it some thought.
Correct. Correct.
This is what we intend to do.
Yes.
You can complete what you want.
True, true. And nothing much is left. Only one thing about post the discussion, we also had some further discussion. Now,
There's one thing we wanted to, when we read this 18.5, just if we come to this judgment,
yes,
we just wanted to flag one matter, issue. If you come to page paragraph 197 of common cause.
yes.
So yesterday you made a suggestion that those in the vegetative condition,
PVS.
previous, should also be part of,
Yes.
be treated, I mean, should be getting the benefit of this advance,
Yes.
what do you call that? Whatever you call it.
Advance directive.
No, just read this para 197. Because in the context of townbound,
Yes. Having dealt with principles in vogue across the globe.
just a moment.
Sorry, sir. My apologies. Lordship may take page 129 of the SEC volume.
That's right.
May I start?
Yes.
Yes. Honourable Lordship. Having dealt with principles in vogue across the globe, we may presently proceed to deal with the issue of advanced medical directives, which should be ideal in our country. Be it noted, though the learned counsel for the petitioner used the word living will, yet we do not intend to use the said terminology. First, we have already stated that safeguards and guidelines are required to be provided. First, we shall analyze the issue of legal permissibility of the advanced medical directive. In other jurisdictions, the concepts of living will and involvement of attorney are stipulated. There is no legal framework in our country as regards the advanced medical directive, but we are obliged to protect the rights of citizens as enshrined in Article 21 of the Constitution. It is our constitutional obligation. As noted earlier.
It is here that we wanted you to. This sentence, please read.
Yes. Next sentence.
Yeah.
As noticed earlier, the two-judge bench in Aruna Shanbag has provided for approaching the High Court under Article 226. The directions and guidelines given in this judgment would be comprehensive and would also cover the situation dealt with in Aruna Shanbag. The reason is that Aruna Shanbag said go to the High Court.
That's right. That's right. That is when Aruna was alive. Somebody took up the key. I think
She's 28 years. She was 28 years.
37 years. 37 years. So what you're saying is this last sentence at least gave us the impression that the directions and guidelines to be given in the judgment would be comprehensive and would also cover the situation dealt with in Aruna Shanbag.
Yes.
So what we want to find out from you is, supposing somebody is in a vegetative condition and in his advance, he says, if I go into an advanced vegetative condition, then also, it should be
Life support should be withdrawn.
whether this sentence was what the court intended,
Yes.
but when it came to actually articulating it
Yes.
in 198.4.1, it refers to in the event of the executor becoming terminally ill
Yes.
and is undergoing prolonged medical treatment with no hope of recovery and cure, then etc. etc. So will it impliedly cover vegetative condition also?
Yes. And
It was intended, but then,
intended because Lordship.
but then the doctor says no.
No, page 475. Page 475.
And very little incongruous, because actually in Aruna, all that the doctor said has been reflected. What is the condition of somebody in a vegetative condition where she's smiling, she's responding? I mean, only in the form of in a very brief smile. And therefore it was found that no, we will not allow it to be withdrawn. The petition was actually dismissed.
Correct. But they approached the High Court.
And that's what I'm saying. No, finally it was dismissed.
Correct. Lordship is right. They said no.
It was, in that case, it was withdrawn. So how does it gel actually? I mean,
Yes.
how do you?
Yes.
No, my lord, as far as
Just see that, if you just see that,
Yes.
Kanju judgment, you have to just refer to that.
I'll refer to that. Can I take your lordship permission to refer to para 475 of the concurring judgment? Because that will show that this was also argued.
Right.
Yes. Lordship will just come to page.
And one last thing before we found also, first of all, this is not a petition styled as one for modification even. This is styled as one for clarification.
Until lordship.
Number one. We found, secondly, the counter affidavit of the state union is one which puts up at least appearance of a stiff opposition. It says it should be dismissed. If that's you have come around to some kind of a reapproach between you both. I mean, it's a different story altogether because we don't know how it happened. But in the counter, the pleading is, which we would necessarily have to refer to, that this is actually only
Adversarial.
no, adversarial, and it cannot be all safeguards with this.
Just to fill up the vacuum is concerned, absolutely we are for that to simplify the procedure within the this one.
We are just telling you because
Yes, no.
readings also.
I missed that counter part of it.
We went to the counter
Because, sorry, I'm sorry.
we saw the counter so that we have to say that in departure from the pleading, a different stand has been taken by the union to the extent that they are agreeing with you.
Yes, yes. Lord, I'll tell Lordship what happened. We moved the application for clarification because this judgment came in March 2018 or 19. 18. 18. Then subsequently, when this was there, then we found that people who went to apply for advance directives could not do so. The judicial magistrate would not take. So there were a lot of hurdles in that. Then, as I said, then when many doctors met her also in Madras, I also spoke to some doctors in Bombay from leading hospitals. They said this kind of a review board will not work, collector will not work, etc. is unworkable. Now, what is the remedy? So at that time, there's a constitution bench presided over Justice Sharun Mishra. So we mentioned to the bench and said that, look, this is the problem. We are going to move this application. The Lordship heard us for a short while and said, and then we also said these are practical problems. Then they issued notice. That's how the matter took off. And then it was heard once. Again, we point out the practicality. They said post for hearing, etc. That hearing. Now, when the matter came, it was not.
We filed the review, it had gone in circulation.
Yes.
You know what happens?
Yes.
It will go to the judges who heard it.
Yes. Yes.
So
It will be a terminal case in the light of it.
the many possibilities would have been there. They could have put it for oral. I mean,
No, but the Lordship is right. One option was to file a review.
it had been done, and it had been mentioned. Probably they would have put it for oral hearing before the same judges who had the opportunity of discussing it threadbare, as my brother said.
But actually, what happened was by the time this came just before in March, April. True. But other reason the review may not have been filed is that we thought that this is basically not an error of law. We are not questioning the judgment in that sense. We are only questioning the direction which were issued, which with all good intention.
That is the nub of the matter. The ultimate the analysis. What is it that it's an error in the order?
Yes.
That's a review.
But we can also, if the Lordship wants to revisit it, we can file a review also. That's not an issue. We can do that. But we moved the application for direction.
We have spent as my brother.
Yes. No, we'll move the application. But in case they want to file a review, we'll see later.
Assuming this character of a suit in perpetuity, what we call continuing mandamus, and their directives are.
Yes. No, but what happened was, I discussed.
But this is not like that.
No, actually what happened, we had not suggested any draft guideline. We only wanted to accept that an advance directive is legally valid in our constitution, though there is no statutory framework. An advance medical directive must be given legal sanctity. And that was accepted by the court. And Lord, in the law, now just take page 475, page 251 of the judgment, since the Lordship referred to page 197. Kindly come to page 251.
Yeah.
Yes. Now, please see page 472, first two lines, 473, two lines, then 475. Advanced directives, page 472. Advanced directives have evolved conceptually to deal with cases where a patient who subsequently faces a loss of mental faculty to decide has left instructions when he or she was possessed of decision-making capacity on how future medical decisions should be made.
Page 250.
Sorry, 250, my apologies. Para 472. The concurring bill.
I'm so sorry.
Yes.
But if your lordship sees the book, it may be better, my lord. Some confusion in the paragraph number.
It's
No,
SEC online.
That's a problem. We'll go by the book.
That's it.
The photocopy of the judgment is.
It's SEC online.
So if it's a true copy, then there is no problem.
It is SEC online. The paragraph is not adding the name.
Take the paragraph 47.
472, 473. And just two lines and then I'll come.
Yeah.
Or just both page numbers are same, no?
Yes, 251.
250 banner. Can I take a lot to 250 first for 2 lines? Advanced directives, para 472. Para 4, advanced directives are evolved conceptually to deal with cases where a patient who subsequently faces a loss of mental faculty to decide and left instructions when he or she was possessed of decision-making capacity on how future medical decisions should be made in Stanford and Severability. Please come to page 473. The principles of patient autonomy and consent are the foundation of advanced medical directives. A competing and consenting adult is entitled to refuse medical treatment. By the same postulate, a decision by a competent adult will be valid in respect of medical treatment in future. And that's called subject standard, that when he was conscious, he didn't want treatment. Therefore, when he's unconscious, his respect should be visited. Now, please come to 474, which talks of permanent vegetative state or permanent persistently unconscious condition. Lordship has got 474, para 474. Advanced directives are thus documents a person completes while still in possession of decisional capacity about how treatment decisions should be made in the event he or she loses decision-making capacity in future. They cover 3 conditions: terminal condition, persistently unconscious condition, and an end-stage condition. Terminal condition is an incurable or irreversible condition which, even with the administration of life-sustaining treatment, will result in death in the foreseeable future. A persistently unconscious condition is an irreversible condition in which thought and awareness of self and environment are absent. An end-stage condition is a condition caused by injury, disease, or illness, which results in severe and permanent deterioration indicated by incapacity and complete physical dependency, for which treatment of the irreversible condition would be medically ineffective. So these are the 3 things.
But that is the doctor said yesterday, this persistently unconscious condition, you cannot say, because after some 12 or 13 or 20 years, somebody may come back.
Yes.
That is what
They agreed. There my answer is, suppose a
so it
person...
cannot be said that it is an irreversible condition. That is what.
No.
One point. In the Anna Shanmok case where she was in persistent vegetative state, there were medical criteria for the diagnosis. And this diagnosis was made by a panel of doctors.
The brain stem was working.
No, brainstem was working, but this was a vegetative state. There is permanent state of unawareness. So there are medical criteria. You cannot say that somebody will
In the case of Shanbag, her brain stem, you see that 2011 4 SEC judgment, where the court has drawn the diagram also, then found the upper brain, the whole thing died, then you can signify it as death.
But not brain death.
She was not on mechanical support, life support. She was breathing on her own.
It's the analysis of reporting.
Analysis of very good. Just see the judgment.
Just in paragraph 45 of this judgment.
It is analyzed for legislations.
There are 2 distinct conditions: brain death, which is brain stem death, and BVS, which is a permanent state of unawareness. And that is diagnosed through medical criteria. So that was that procedure was gone through in the Anna Shanmok case. So she was in a PVS by medical criteria. And she had not woken up after.
Just see 2011 4 SEC.
Yeah. 2011 4 SEC.
It's important that you see it because this is the backdrop in which the whole case, the 3 judges then doubted it and then went there.
2004 SEC.
Come to page 516.
I just don't have that book. I'll just get it from the library. But just while I get the book, To answer my lord, this is Ravi Kumar's question that PVS and what doctor said. Can we not have a situation where, as part of the advance directive, my own advance directive, so the patient's advance directive, he says that, look, should I go into a permanent vegetative condition, which is medically defined, then the possibility that I may get after 10 years or 12 years, I don't want to be lying in bed for 10 years. So let me go peacefully. Is that not open to me? Because now you say if I can, when I'm mentally conscious, if I can refuse medical treatment, I know that I got some illness. With medicine, I can live for 7 years. But the medicine is so horrible. I don't want to take, I'd rather go away. So I'm just, sorry.
Kindly come to page 515 of the SEC. 515.
Yes.
It's replete with a diagram.
Yes, yes.
And this scheduled judgment. Please read brain dead, under brain dead, the discussion.
112, no?
515, 112. Please read that.
Yes. Brain death. All your lordships have got it. All your lordships have got it.
This is Roy.
Yeah.
Brain death may thus be defined as the irreversible cessation of all functions of the entire brain, including brain stem. It is important to understand that this definition goes beyond acknowledging consciousness. A person who is incapable of ever regaining consciousness will not be considered to be brain dead as long as parts of the brain, for example, brainstem, that regulates involuntary activities such as response to light, respiration, heartbeat, will continue to function. Likewise, consciousness, albeit severely limited, is present, then a person will be considered to be alive even if he has suffered brainstem death, wherein breathing and heartbeat can no longer be regulated and must be mechanically determined. Hence, the international standard for brain death is usually considered to include whole brain death, that is, a situation where the higher brain, the part of the brain that regulates consciousness and thought, the cerebellum or the midbrain and the brainstem have all ceased to demonstrate any electrical activity whatsoever for a significant amount of time. To say, in most cases, that only the death of the higher brain would criteria for brain death may have certain serious consequences. For example, a fetus technically under definition would not be considered alive at all. Similarly, as per this, different definitions of death apply to human and non-human organisms. For the facility of readers, discuss in the judgment if read is given. Then
Now we come to page 518, paragraph 121.
Yes.
Morning.
From the above angle, it cannot be said that Aruna Shambal is dead. Even from the report of the committee of doctors which we have quoted above, it appears that she has some brain activity, though very little. She recognizes that persons around her and expresses her likes and dislikes by speaking some vocal sound and waving her hand by certain movements. She smiles if she receives her favorite food, fish and chicken soup. She breathes normally and does not require a heart-lung machine or intravenous tube for feeding. Her pulse rate and respiratory rate and blood pressure are normal. She is able to blink well and could see her doctors who examined her. When an attempt is made to feed her through mouth, she accepted a spoonful of water, some sugar and mashed banana. She also licked the sugar and banana paste sticking on her upper lips and swallowed it. She would get disturbed when many people entered the room, but she appeared to be calmed down when she was touched or caressed gently. Aruna Shanbag meets most of the criteria for being in a permanent, persistent vegetative state, which has resulted for 37 years. However, her dementia has now progressed and has remained stable for many years. From the above examined team of doctors, it cannot be said that Aruna Shanbag is dead. Whatever the condition of her cortex, her brainstem is certainly alive. She does not need a heart-lung machine. She breathes on her own without the help of a respirator. She digests food, and her body performs other involuntary functions without any help. From the CD, which we had screened in the courtroom on 2/3/2011 in the presence of counsel and others, it appears that she certainly cannot be called dead. She was making some sounds, blinking, eating food put in her mouth, and even licking with her tongue morsels in her mouth. However, there appears to be little possibility of her coming out of PVS, which she is in. In all probability, she will continue to be in the state in which she is till her death. The consequences of the life support system.
Thereafter, the court in paragraphs 124 proceeds to deal with the case of PVS and what
Yes.
remedy
Yes.
for relatives.
No, I'm,
A writ petition, parent petri jurisdiction is
Yes.
referred to,
yes.
and then the
Parents
remedy,
Petri, yes, Lord's
and a team of doctors to examine them. And finally, in the end, the petition was dismissed as far as Nordberg is concerned.
Yes.
Now we pointed out to you paragraph 137 that, that where he said that the guidelines will cover situations governed by Schonberg case. What is the meaning of that?
I'll put it this way. Suppose Aruna
I don't
Shanbhag,
understand. What is the meaning? Was it to be covered? Was it to be not covered?
no,
As long as life is there, and as doctors say, there's a possibility of your going back. You don't know
no,
what.
here, but Supreme Court has said there is no chance of work. I'm just putting it this way, Lord. The chance of
area.
No, can I say one thing, Lord? Lordship will just imagine, Lordship asked, what was the court intending when they said it will cover Aruna Shanbhag? I'm requesting your Lordship to visualize. Suppose Aruna Shanbhag had given an advance directive that should I come in this condition, please don't continue my life support. Now today she's not on life support, so maybe it's a different situation. But suppose he was chosen a PVS and required life support, required so much thing. And then the point is two things, withdrawing life support and not providing life support. Here she was living with life support. I mean, she did not require support.
Para 136, in fact, the court discusses about suicide. What is
passive? Assisted dying.
Para 136, you get the
Yes,
whole.
yes, yes.
So, and doctors have been sort of told that it will not amount to suicide, 306, 309.
Assisted dying.
Yes,
I don't want treatment that's not diabetic.
In fact, there was a recent gentleman in Australia. He was very aged and he had some kind of a terminal. So he wanted to go. So he went to Switzerland and there they can administer lethal injection at your choice. So he said that I want that. It was his choice. There was no hope of his recovery. And they actually administered an injection. And he said that he wanted his favorite Fifth Symphony or something to be played in the last moment. There was a big article on that. It happened. He had to go to Switzerland and do it. I'm only asking.
A refrain which you find very perseveringly persistent in all these judgments is about the conditions obtaining in our country.
Yes.
About the absence of ethics.
Correct.
About a lack of morals, which might drive profit-driven conduct. Beware of it. The court says, throughout we were just seeing it. Relatives might be very, very, enamored of the idea that this lady should not go through a particular treatment, not because of that lady, but because you will get to her wealth very quickly. So beware of it. We also should be beware.
No, that is why.
So the safeguards.
That's why the advance directive is done when she's fully conscious, and that's why a Lordship put the safeguard of witnesses and putting before notary public, putting in the national health record. Number one, my only humble submission is the possibility of a misuse, therefore it's a relevant factor, cannot deny the possibility of a person.
That apart, what is your submission? We just wanted to highlight.
Pardon me?
That apart, what is your submission?
My submission is this, Lord. Now everything has been agreed upon. The only hurdle which we are facing is what about the review board? Primary board we all agreed upon. This is Rastogi also suggested. Team doctor, 2 subject, Lordship made it 3 doctors.
I'll tell you something more. Now that it strikes us. See, Government of India, please listen. See, you should realize one thing. Areas which are meant for the legislature to exercise its power.
Yes.
By not exercising the power.
Yes.
And by actually sort of agreeing to all these things being issued by the court, you are actually passing the buck. And you are actually, okay, ultimately you will say, see, we didn't do anything. Actually, court ordered it. You are abdicating your legislative, we can't be telling you the legislature is a body. But then finally, under the, scheme of separation of powers we have, this is squarely a matter which you should have taken up.
But it was.
We are just telling you.
Yes, yes, I understand. But it was deliberated upon.
How it to, what we do or what we not do is not the important thing. This is a matter where the chosen representative will debate and finally very meticulously detailed. I think which will have greater amount of wisdom. Thing which we don't have. We don't have the expertise except what you are providing us.
In fact, the guidelines framed by this court, nobody had given the frame. Court framed the guidelines after consulting seeing the submission. It was not put the draft guidelines to the medical.
The whole idea of
No, if this court had given these draft guidelines and given it to the medical community, they could have got a feedback at that time itself. It came straight away as a part of the judgment.
Actually,
In short, my submission is this.
the issue was,
Suppose
let me-
Avinash-
one second.
I'm sorry.
The issue was actually deliberated upon. We have filed an affidavit to that effect, and the original writ petition that may clearly be looked into. It was deliberated upon. It was referred to 3-4 times to the expert bodies, the doctors. Then thereafter, finally, the government has taken a conscious decision. We need not go for any
You
legislation.
did not, you know that.
Yes, that is a categoric stand we have taken in the original writ petition. It is not required or should not be done because it for various reasons also have been given. I think if possible, can
So
you
do
look
you
at?
agree with the original directions or are you agreed by it?
We are not agreed with the original directions.
So you're accepting it?
But we have accepted it as it is. It is now he is seeking certain this one clarifications.
So what is?
Please,
Get the drift of my question. My
Please.
question was,
please.
if you think a law is not needed,
Yes.
but the court makes a direction which have the garb of a law under Article 142,
Yes.
it's binding.
Yes, binding.
You have not filed a review.
Yes.
You have accepted it.
Absolutely.
But I'm quite, because we had multiple meetings after meetings after meetings, and we both agreed that
That's right.
these guidelines are not
Okay, so what
workable.
is your next point, so that, we can go to that?
Yes.
What else you want?
Whatever that you provided to us in this miscellaneous application, have you consulted the government?
Yes, we had multiple meetings.
Multiple meetings have held.
That's we are.
Yes.
You also
Yes, we had a meeting.
suggest us.
Yes, that's what now yesterday we suggested about various things. Now only about the now
The
the
whole, the entire concept of primary board, review board came after discussing with the DGHS, AIMS director, health secretary.
Have you put up a joint kind of thing?
We had multiple meetings.
No, I'm telling you about you and the government.
Yes,
If you could put up a joint proposal
yes.
or altering it,
that would be
Yes.
that would be the best way because
Yes.
in which case, it makes our, not only makes our task easier, there will be clarity.
Yes.
Then we can chip it with whatever.
Absolutely, absolutely.
Mr.
But I just,
Mr. Dakar, the difficulty that the court is facing that
sorry, ma'am, yes.
you see, a particular stand is taken
Yes.
in the affidavit that has been filed.
Yes.
And although there have been very many discussions, that is not forthcoming as a common document, authenticated by the government.
No, this is the steps which we both agreed upon based on discussion. The
No.
primary board and review board.
Should it not come across together?
I think
No,
it
no,
would
no,
it would be better if a comprehensive proposal comes
No,
from
that is
both of us
possible.
together.
Exactly.
We are not, it should not be taken as an adversarial thing. In fact, we are very much with you in the manner that you are projecting and the difficulties that you are projecting. So you also must not think that, but only thing is that once in a while, there are reactions coming on the basis of instruction received across. We are noticing that.
Yeah.
Of course, Mr. Natarajan is also perhaps bound by the instruction that he receives.
Yeah.
So that is why the difficulties are happening.
Yeah.
We are getting a bit of a contrary kind of signals.
See, your stand at the, before the constitutional bench is
Yes.
evident from paragraph 10.
Yes.
Paragraph 10, what was stated in the convoluted was that conjunctive.
Yes.
You said that it was elaborately considered, but then you are not in favor of enactment due to the reasons. You have given the reasons.
Correct. We said so. I'm grateful.
Mr. Natarajan,
Wait.
you must be having this,
Yes, I have this one.
suggest us with the government that
Yes.
all right, these can be workable, these are not workable
Put
to
it
us.
as joint.
And what is not workable, what could be
I can
to
do it.
make it workable?
I can do.
Ultimately, that Mr. Datar is not interested that no, nothing doing what he says final.
Yeah.
He only wants the things to make workable,
Yeah.
and people should get the fruits out of it.
Yes.
Otherwise, the 1,000-page judgment is not only for the papers to be placed.
That's right.
That people must get benefit of the final verdict being given by the court.
Yes.
To be implementable. No?
That's the most important. Obviously,
Understand.
otherwise, full volume has been consumed.
I can prepare this is specific comments on each of
Over the weekend, then just prepare this.
In fact, what
Hand over
happened
to
was,
us.
yes, in fact, what
We
happened
can
was,
do it by Monday.
Very well.
Also read it and come and dictate order.
Very well.
No reserving, nothing.
Very well.
no, I'll tell you what, what happened is,
You know what it is? This might be actually, it'll iron out many and three.
Yes, I'm just saying, the right of my friend said, what happened was an order dated 22/1/2020 is passed by a 5-judge bench. It's Arun Mishra, Indira Banerjee, Vinit Saran, M. R. Shah, Bhatt JJ. Let response be filed within 10 days. It is submitted by Learned Counsel that they are trying to convene a joint meeting of all the stakeholders. Let there be a joint meeting in the meantime and consensus if any place before the court. The case is adjourned.
So that consensus has not been placed before the court so far.
That's the step 1 to 6 of the consensus.
It doesn't, they are having objections, for example, they are having objections to the vegetative condition. They have raised objections before that. So it can't be a joint. That what you're saying is something different. If both of you can, once you agree on what is the irreducible minimum, as it were, on which you are actually coming to an agreement, and it is in writing, it will be easy for us to either accept it straight away or with such modifications coming with themselves to us, dictate the order. Why create any kind of, because see, we are here.
I get the point. Instead of we deliberating this, the line, that line, why cut it?
Why?
And then it's your lordship to say, no, we don't agree, we agree.
Yeah, because ultimately the most important stakeholder is who? The government. Because it should be the body. What in the sense that it is the body, normally it is the government which will move the bill, which will become law. And that's how it should have been done. But here, government in its executive capacity is before us. And to the extent that they can help us resolve the problem, we'll take inputs from them. So here we'll have clarity, because what will happen is, one word not here, one word missing, one word added extra. You will come again next time with another clarification.
Again 5 judges.
So why file do this?
What I'll do is,
This weekend, over this weekend,
yes,
if you sit together,
yes,
both of you,
yes,
and file it by Monday.
yes.
Can I suggest one thing? I've given my corrections in red because this, so whatever they don't accept, let them say so, then finish it off. Because Bharati Lordship, why not? Or after yesterday, after 5:30, again I talked to a number of people. Just 2 points I'll mention and I won't take. Now we are all agreed 2 things. We are agreed that the direction as existing will not work. We are all agreed joint mindset should not be there. Agreed. We are all agreed that look, it should not be just an advance directive because of the Indian condition. Somebody may take advantage of it and say, oh, this advance directive, finish it off. Therefore, they say, no. Despite advance directive, let it go to a primary board. Then the Ministry of Health suggested, look, instead of having a primary board, you're taking away somebody's life, let it be subject to a further second-tier review. Many doctors I spoke to, they said, you have to trust us. Where's the question of review board? Other important feedback we just put on our affidavit, and I spoke to some leading surgeons. They said, look, the statistics show that from the time a person is very often terminal, it's a matter of days before because you're withdrawing life support. We're not talking about if it's a terminally ill cancer patient and he's living normally, then he fills that AIM form and says that ultimately if the time comes, don't have this inappropriate treatment which that form says so. We are now talking of a case where a person has gone into a coma, he's on ventilator. Now, what doctors told me is just be practical. Is it a time to have a primary board, a secondary review board, go to the collector, put it there? So they are saying that, look, it won't work. So we are talking of, and every day of intensive care is costing a fortune unless he's in a government hospital. So when I said primary board and review board, what I was saying was if a person has gone into a coma, like an accident, he is brain dead, but he's on ventilator support, he has to be kept breathing alive. So they say that, look, and the statistics show that we made how many, or the 1,000 odd cases. Yes. Just show the. Asura Medical Hospital. There are 474 cases where such decision had to be taken per year in 1 year. Then we have got cases where they examined 2,000 cases all over India, and they said that in more than some 70 odd cases, the time between this happened and the end of the life was hardly 8 days. So that's why this primary board, review board becomes impractical. Then all our exercises are reduced to futility. So as long as there's advanced directive and there's a safeguard.
Subtle aspect which struck us. The case of Schoenbach, she was in a vegetable condition. Why? I'm never able to pronounce.
The attempted rape and somebody hit her with a chain and all that.
No. Vegetative condition. 37 years. Correct? the court dismissed her petition, but then court also said, you can file a writ petition. What is the meaning of it?
No, because they say the High Court judge with parent patria jurisdiction.
No. What you're saying in the case of
my friend can
in the case of Schonberg, it was dismissed by this court.
Yes.
Because they didn't agree that Pinky Irani, the petitioner who had filed it, was the next friend of Aruna Schonberg. They took into account the wishes of the nurses and the caregivers of Aruna Schonberg at Cape Hospital.
She should be
They
kept
wished
alive.
that she should be kept alive, therefore they dismissed them.
That's right.
It's actually a book
It's a
on
pro-life
Pinky
approach.
Irani.
Basically, it's a pro-life approach.
In fact, Mr. Datta, I'm just having here, you can just look at, ask one of your colleague, Lushin Dubey's Aruna story. This was enacted this Saturday. Lushin Dubey is one of the most celebrated actress in India. So this Aruna story, eventually the nurses, they all said that we'll take care of her. Don't allow her to die.
Because she was a nurse.
She was a nurse, she was raped in the...
Yeah, and then when the person was chained, yeah.
So Aruna's story, just last, I think Kamani Auditorium or something, Lushin Dubey. She's one of the most celebrated actress, Lilith Dubey's sister.
No, I'll tell you what's it now. At the end of the day, the only problem...
Let them know about your theatrical. The thing's going back to
But we can hear it now. We have heard it now.
So theatre person has got so much of knowledge of theatre, himself a director, actor.
No.
Many people do not know that. I mean, it brings to impact even some of the judgments I find literary, gems coming in. From where he gets it from there.
No,
But I was told this is Vivian Bose was interested in magic. He's interested in magic.
Out of the world.
Out of the world.
Out of
And
the
he
world.
drove from India to
No one can come anywhere near it.
But you worked a lot on Palkiwala. He also used to perform magic for children.
initially, yes.
Who used to visit him and all.
Yes,
Just to sort of entertain them.
Also very great violinist, very good violin.
Violins.
So you can just, we thought that.
No,
So what I suggested, by tomorrow or after tomorrow, I'll convene a separate meeting where I will request my friend also to be present and with on Zoom, whatever the platform is required.
You're always
Yeah,
keen on
always.
Zoom.
I know, he's so busy, has to be in Chennai on.
We had multiple meetings.
Yes.
No, what I'm requesting is.
So that, by Monday, you put it down in writing and give it to us.
Yes, so that I can place
So
it
I'm
before
asking
it's on.
your lordship now, on the basis of all our meetings and the basis basically on your lordship's feedback. The only Mr. Nataraj will agree with me. We are all agreed on a primary board. We are all agreed that JM should go. What your lordship has to finally take a call is what about the review board? That's the point. And what is the time limit? So two things are only, Mr. Nataraj.
No, something more is required. Something more is, now after review board takes every decision. No, according to them, it need not be, that's end of it. But however, we have a caveat. After review boards takes a decision, at least that decision will have to be given to the learned magistrate. It must be preserved. Because there will be future litigations and so many consequences will follow. Some kind of check is required, number one.
To iron that out between
Yes, and all these issues will be sorted out.
In all our meetings,
that is not.
I'm very surprised, with great respect, when all the multiple meetings I had, there was no mention of magistrate. We all agreed magistrate is not practical.
That is for the procedure.
Your time is, we know that.
No, I'm doing sort of, it's a labor of love. I'm not
No,
saying-
we know that you're doing it forward, so that whether it'll spend more time, it'll help the court also to.
Can you also put it on Tuesday, on Wednesday instead of, because
Tuesday, when we'll have to sit for a prosecution bench.
No.
Tuesday, we are sitting and we can.
Yes, because the other matters are continuing. No? The other that WhatsApp privacy, all that is now.
But WhatsApp, who you are appearing in that?
Yes.
What
The symbol is there.
I'd like to know
Yes.
what happened actually. Is the government supposed to come with a law and all that?
No, the bill is being finalized.
Bill is being.
What is going to be the standard? We have to hear that. We thought we were.
I don't think that.
Actually, what happened was, when the matter was posted in January, and what she posted it, they said that they should not take an adjournment of bill is filed.
That's what
Now,
Shah
what
was
happened,
saying.
yes. Now, what has happened is now an elaborate bill has been given. So it's up to your lordship to decide whether the bill, we have also made a table, what are the concerns and how the bill has addressed them. Because then it's a legislature. So that your lordship will take whether it should be a court issue or that your lordship may take it because this is.
That's right. We want Joseph Shine, that's another clarification application.
Yes.
There is so what you say? We wanted on the next.
So Tuesday Lordship is sitting in any case, no?
We are sitting on Tuesday, so we can we put it tentatively on Tuesday?
Yes, post lunch.
So that.
Well, I'll do one thing since I'm not there tomorrow. I'll ask my colleague to sit with.
Right.
There's no whoever can
Because it's,
And I'll also join in on the
otherwise
video.
the whole thing that happened there, you'll again have this, we'll say something and then you'll say it's not.
The only thing tomorrow I'm in Bombay High Court, actually I may be stuck there. So I will also join in the afternoon post lunch.
We'll have it on Tuesday.
Yeah, well, no problem.
So this is what we expect so that we can dictate.
Yes, absolutely.
We better.
But I will also ask Mr. because Mr. Natraj is also there, but all the early meeting, multiple meeting we had, and on the basis, Lordship will see this 6th step which we gave is from the ministry. On the primary board, review board, that's on the ministry. Yes. So now what your Lordship is saying is, we had a ministry with 2 people. Why not just, Joseph said, no, let it be 3. Okay, 2, 3 becomes 3. Now, Lordship may also think, my suggestion is the weekend also.
About the 20 years.
20 years, and also on the review, because keep in mind, our humble submission is, the time is of this, is clock is ticking minute by minute. So if you're going to have a bureaucratic approach of, say, a primary board, a review board, magistrate to confirm, then till that time, the person has to keep on being on put ventilator. Then what's the point of him saying that if I'm going on ventilator, remove it? What's the use of the advance directive then? If your Lordship is going to put a magistrate, then we might as well close the hearing.
No, not magistrate.
Not for the proceedings. Once it is concluded, it must be this one ultimately final. That is our concern. Let us not be anxious to.
Mr. Gadar, if you rightly understood him, he doesn't want that he should intervene.
Yes.
After the board take a final decision,
Correct.
that opinion expressed by the board either way has to go to some magistrate.
Yes.
You can convert from magistrate to executive magistrate. You send the paper there.
Yes.
That executive magistrate
Yes, some kind of-
to intervene.
No, what I'm saying is,
Ultimately, the opinion of the doctors is final.
no, I'm saying.
The fellow has no about to
Yes, I appreciate it. I'm asking myself the question. If a primary board, a review board has confirmed that Mr. X is terminally ill, please don't put ventilator. What are we discussing? That day-to-day life support need not be given. It's benign life support.
There we can chip in with something which might help. We can think of some timeline.
Yes.
There you have to actually say.
We'll discuss on that. We'll discuss and
that you can say and we'll incorporate it.
And what we can
that
do
will be the best safeguard.
is, and humble request that my friend also can consider. Let the decision is being recorded. The reasons are given for withdrawing the life support in terms. That is a hospital file.
No.
Now, if it is going to be in question under article, the record is there. Now, by giving it to a magistrate or a secretary or a ministry, how does it make a
What he
difference?
intended was.
Or can I say this one thing? Sorry.
You have perhaps not understood what he
Yes, yes.
What he's saying is that once the decision is taken by the review board, for example, that it should be communicated for it being kept as a record.
In part of the medical record,
Not for the
digital records.
He's not going to sit in judgment over.
Correct.
No, then why can't it go to the national digital medical record itself?
Well, let it be with the official body.
Yes.
No, that's a government body.
No.
That's right. No.
Let us not be anxious.
You find you got
Let-
that out.
I'm-
The National Digital Health Mission, which has got its records.
That's how you can hide that out. We have no problem whether it goes to science stage or whether it goes to this man or that man, whichever man.
No, Mr. Natarajan.
Yes.
National Digital Health Mission.
Yes.
You take instructions because you see that's already there.
Yes.
Whether you want to bring in a third party, meaning there were third party as we are talking about, not
Yes.
otherwise strangers,
Yes.
magistrate, collector. What I'm saying is you have a digital health mission portal already.
Right.
So if you keep it there,
Yes.
it is protected. So obtain your instruction.
I'll get instruction.
Let it come as a joint kind of a thing, not come from your side.
Yes.
Because at that point of time, instead of 2,
Yes.
3, we are debating this.
Yes.
And that's actually derailing the smooth flow.
Correct. That's right. I'll get it. I'll try to.
It would be practically impossible.
Impossible. Correct.
In many places.
Correct.
It is not a simple thing to have and such an experienced doctor to have him over on a medical board.
That's right. That's not possible.
Somebody is taking care of critical care
Correct.
patients.
Correct.
Ask him that please come and attend to
Correct.
this.
Practically not. Practically it's a practice.
So these are, he'll have to give up on treatment that he's rendering to somebody
Yes.
and then come and
Yes.
participate.
I agree on that. And we are also on that same, on the same page.
I don't think if you speak with Mr. Datar and Mr. Natarajan, perhaps you will be on the same page.
Same page.
Only thing it should be forthcoming
Yes.
as a common kind of a document.
Only thing we have some kind of difference only on some of the issues, like there must be a proper check That we should not be anxious to take away somebody's life, whereas our concern is to protect somebody.
Nobody
Yes.
would like to.
Yes.
There's a contrary we are discussing. Let me not take part in that discussion.
Yes.
I have something called whose life is it anyway?
Yes, yes, yes.
There, somebody was saying that let me die.
Yeah.
And the hospital attendant said, why should you die? The patient, who is totally confined to bed, he said, what life, what use of life do I have? And then the hospital orderly told him, you can do so many things. What can I do? Well, you can say, look at people who are traveling around in your room. Yes. You can umpire a tennis match. And if you are, feeling a little, this thing, even table tennis, umpire of a table tennis, referee of a table tennis match. So, that was an argument, counter argument, in whose life is it anyway? Very celebrated play of production of UK, where the patient was being persuaded not to end his life.
So you're partly converted Datar.
My brother has bought all literature.
Right away, suppose it happens to me, I know I can watch the table tennis match or tennis match.
Correct.
No, since your lordship said don't quote foreign judgments, I refrain. But if your lordship sees the UK judgments, what they say is...
We didn't say that. We didn't say don't quote.
No, lordship said Indian conditional reference, so I refrain from showing that. The general trend of the law is when a man, and that's what Justice Severability says, called a subjective standard test. This man, when he was conscious, he said, I don't want indignity. So when he's unconsciousness, by making these multiple checks, you're making him suffer indignities.
That
primary board, secondary board, magistrate, that man, you're very vicious.
I'm making very, let us not be anxious to take away somebody's life. There must be proper check. We are concerned about. We are bound to protect it.
We're not taking anybody's life.
That's what you're in a hurry you want to take away.
Says that if the advance directive is there, even if somebody else wants to, please respect him. Suppose Aruna Shah had been a medical directive. Suppose Aruna Shamba had made an advance directive. What would we do?
That actually, we are actually, in this whole debate, we are...
we are playing God.
Not playing God. We are belittling so many other values.
Yes.
So many other values, that's a larger debate which we...
Correct. What I'm asking is, when you're talking of value...
When you want to, if you're becoming so kind of thing, you're understanding of what is suffering, what is life, what is the spirit, what is God, whether you're an atheist, you're agnostic, a whole lot of them. That's a larger debate. Let's not get there.
Arun Shuri has written a book. He says we prepare for everything, but we never prepare for death. It's a lovely book. It has gone into different areas. And he says, how do you prepare yourself for dying? And I can give a copy to your lordship also. It's a very book. Only thing, there's a book which you can't give anybody as a gift. I can't give anybody a birthday gift, how to prepare for dying. That's the only problem. Otherwise,
is his son's photo on the cover of the book?
No,
his son's photo.
Yes, no, his son is being blessed by Dalai Lama. It was believed by the Dalai Lama. And his son who's completely a vegetable. Actually, he's 6 feet 3 inches, but he can't have cognitive faculties. So he put his hand on the Dalai Lama's head as if to bless. So that's a photograph there. But it's a book for preparing for dying. He says we prepare for so many things, but we never prepare for dying.
I know somebody who's, the parents both are doctors, but unfortunately they got it wrong. Their first child was born with cerebral palsy. Correct? They're in the States. They get the best treatment. So I've seen them, I watched them. So the father says he cries. Whenever they have parties, he goes into a room and he cries. Can't see his daughter. But the daughter is the very, the whole joy of their life. It's about 40 years.
Same thing.
It all depends upon how you look at life.
In fact,
if you are pro-life, you want to think that, that okay.
No, these people are actually walking, talking. The only thing they have the mind of a 3-year-old or 2-year-old. That's the whole, that's a totally different thing. You're talking of terminally ill patient, right? The end is imminent.
That's right.
And in fact, Mr. Shuri also, because perfectly normal child didn't get oxygen in the initial.
Anyway, my other brother has said about whose life.
No. Since you mentioned Arun Shuri, one more book I think all of us should benefit by reading. That is by Dr. Atul Gawande.
Yes.
Being Mortal.
Yes.
That's another very celebrated book. All about how to live your afterlife. Arun Shauri's son you mentioned. It's a personal thing, of course, but perhaps I can share at this moment. Arun Shauri's house I visited while I was riding a motorcycle, a YSD motorcycle, which made a lot of noise. I and my friend, we had tea in his house, and then we were coming out. Then my friend, I was just starting my bike. Then Arun Shauri saw that this bike is there. He said, "Can you just wait for a minute?" He went back inside. He brought along his son, the same son you were talking about. He made him sit on the bike while the bike was being started. And certain reactions came from the son. And after that, he just said, "Today I have seen some reaction from my son, and you have made my day, my friend." And he went away. This is the experience which I personally had. And that book is currently I'm reading now, Arun Shauri's book.
Actually, also the.
I'm sure that is going to. Yes.
No. In fact, talking of actual government is apart from checklist manifesto being marked. You should also see the book by the Emperor of Melodies.
Emperor of Melodies.
I don't know if you're actually seeing the book Emperor of Melodies
Fantastic book.
by Siddharth Mukherjee. That's also.
He's an oncologist.
Wonderful book.
Here the decision becomes irreversible. Therefore, let us not be in hurry. Let us have a deliberation. Thereafter, we will come back.
What we were saying.
Yes.
Datar might still be converted.
Yes.
No, but after speaking to so many doctors, they just require, please trust us. That's all they're saying. And they say time is of the essence. Time is of the essence. We don't have time for these because we're sitting in court. We don't know what happens in an ICU. We don't know what happens in ICC.
Our brother was so seriously putting it forth. And I was going through the judgment. My feeling was that is in our present system and the busy schedule of individuals, whether we have time to think over about what will be the next. We are so busy in our own schedules. We don't have a time to think. And what should happen to me tomorrow?
Yeah.
In our India, you see, every day in, day out, 7 days, 24/7. We don't have a minute even to think over. When somebody puts on somebody's head, then only strikes to him, what should I do? Otherwise, people are going on. Whether it's a mad race or something else, God knows.
Some life-changing event takes place, then you pause.
You go to funeral, to send some funeral, everybody mind changes for half an hour. You come outside from the funeral, everything is gone back to the same station. Your mobile also start working and you're talking to some people, please wait for some time. I'm in a funeral, I'm attending a funeral, wait for some time. See, the mindset is different.
But if you think actually.
These are the ground realities of life.
It's just like, suppose you are fixing next Olympics. You are saying that it is in 2025, 1/1/2025. Tomorrow, one day it is getting reduced. Next day it is getting reduced. Same is life. Because every day, one day is.
In fact, there's a sentence that every.
So if you are thinking like that, you cannot live.
Yeah. Okay.
Because see, after 1 month, virtually 1 month is gone from my life. If you are thinking like that, you cannot live. So is it not better to think how I should live and think about life? Some very few will think about this thing. How I should die, when I should.
Another thought.
No, what people say, you should think about it also. What they're saying is, why do you, Rasugya says, you're so busy with day-to-day
We
preoccupation.
think that we are fully healthy, but still that age is there.
Yes, you should also plan for that.
Excuse me, correct. That is what you're saying. You have said that.
Should come jointly.
Come jointly, whatever.
Yes,
That's right.
Come jointly.
That's right.
So just
One discussion has happened. Jointly.
We'll come back on this.
One troubling thought. It's not troubling thought. It's how the whole system works. You take a case of a, say, 45, 50-year-old man. Correct? He has been told that, he goes into a sort of stroke or whatever it is. So then he makes advance.
Advance directive.
So he names his guardian. Correct? Then, say, within 2 years, he actually encounters this problem. The day he gets it, he goes into a coma. Correct? So the court says that any time he can withdraw it. He's free to withdraw it till any time. Now, the point of the matter is, it is very relative because it happens all too quickly for him to have a time for revisiting this decision. But this is irrevocable because then, he is not able to communicate that I want to come out of it.
No review.
There is no review. Because the doctor is bound to act.
In fact, the Constitution bench just pointed out that you are entitled to modify your advance directive while you're conscious. Yes.
While you're conscious, what you're saying, you take the case of somebody that where you want to revoke it, but you don't.
No, my only request.
You are incapable of.
Irrevocable. It's irrevocable.
No, my
Once you're gone, you're gone.
No, the point. I thought about this, but I just thought I might thought first. As far as the will is concerned, I may have a second look at whom I want to bequeath my property. But as far as an advance directive is concerned, it's a binary. I have taken a conscious decision that if I get terminally ill, then I should not be put on life support and where the end is. So that I may not change my mind. I will not tomorrow say that, look, I made the advance directive. Now I rethink about it, that even if I'm on terminal ill, I want to be tortured and continue. So I'm just saying.
As reality is, some persons, after an unsuccessful attempt to commit suicide, thereafter they are living about for 25 years. So if they are actually determined to do away with their life, next day also they should, but they will not.
We'll have.
So we cannot say that the persons will not change their mind. It may. It's possible. But in this case, they are incapable of doing it. That's all.
It's too late.
Tuesday.
2 o'clock.
2 o'clock.
Oh, yes.
So this we put it in writing and both
Both
of
of
them.
can I also suggest one thing, sir? So because we already given this entire chart to your lordship. Instead of redoing it, what we'll find out is in the remaining, only up to para 190, your lordship has corrected it.
Correct, we have corrected it.
Yes.
But
So-
it's better, because they have also, they're there.
No, what happened was we agreed on that, whatever your lordship is.
If you are, we are saying that if you can.
But then go from the beginning.
Beginning, whatever is agreed, it will be easy for all logistical purpose also.
Yes,
it
yes.
will remain. It will be part of the record also.
It then give you a real article 142.
Yeah. Tuesday at 2 o'clock.
Will do.
Arbitration, yes.
Please, great.
Arbitration case, yes. That is arbitration.
No, I was just, because we are in this Manipalkul Arbitration Center, we have this day-to-day problem.
Yes, yes.
These new three.
Basing the Valvale judgment for your lordship's consideration.
Yes.
Just 1 minute.
Just
Arranging our.
It is a consistent.
Maybe we follow one set. Easier for us.
I only want to then mark the paragraphs.
It is next big one. Yeah, what's that? I don't know what will happen to us. But I think want to do.
My learned friend Manoj, I just wanted to clarify one factual aspect. I looked at the judgment, my lord, in NN Global, original judgment in Vidya Drolia. The paragraph 92, which is referred to in NN Global, which is referred to in Vidya Drolia, covers 146 and 147 in entirety.
Entirety.
Entire. But it doesn't matter, my lord. It does cover I went through the
You
certified copy.
mentioned 147.1 and 147.
The entirety. The next paragraph 93 starts, my lord, after
It is
10.
doubted. It is doubted.
Yeah. So, my lord, it is accurate. It's not, there's no.
It's
But
not,
in
it
any,
is doubted.
yeah,
The whole thing is doubted.
my lord.
Yes.
So I placed paragraph 22. Now please see paragraph 27. The judgment is
22 of Curability.
22 I have placed here.
Yes.
And it follows SMST notes the provisions of the contract. Now in paragraph 27, the PO judgment is noticed. In paragraph 27, of Galwale, the PO judgment itself is noticed.
Yes.
It said that doesn't arise out of the Stamp Act. The issue is not the same. Please have paragraph 27
Of
Galwale.
Galwale.
The other, I'm so sorry.
So many words.
Page 80, Convenience Compilation 1, filed by me. Jafar sir. Because this Euro was not a case under the Stamp Act, and the issue was only whether one tribunal or multiple tribunals. That is all. You should have seen paragraph 27.
Yes.
The other judgment strongly relied upon by the learned counsel for the respondent is Duro, particularly paragraph 59 of my Lord Justice Korean Joseph, which reads so and so. The judgment also makes it clear that the mischief that was sought to be remedied by the introduction of 1611(6)(a) was contained in the judgments of and Bogara. This judgment does not in any manner answer the precise issue before us. The issue was with respect to SMS, whether SMS is taken care of by the amendment. Now please have straight away the operative portion of paragraph 37. This argument, my lords, was raised that, see, if you put the Stamp Act provision into play, there will be delay. And that argument is at paragraph number 31, page 85. The need for speed, as you put it, in arbitration, the argument is at paragraph 31, page 85. And how is it? The court says it has to be harmoniously construed. May I place it, paragraph 31?
What is the impact of section 9 actually?
Because I will.
That is also touched upon. What is when you go with when you go with an application to section 9, what is the nature of?
They are also the appeal.
Ultimately, suppose the agreement, if it forms part of the court record.
Prima facie case has to be seen, and therefore, my lord, from para 26 and para 37 of NN Global, we will show that there is a contradiction, my lord. Because if this.
Okay, we'll get.
May I place the argument first? Let's para 31.
Yes.
Page 85.
Yes.
The learned counsel for the respondent relied strongly upon section 1113 of the 96 Act to show that a 60-day period would be breached if a document were to be impounded at the stage of section 11.6 application. Stamp duty, when paid with penalty, would require adjudication by the stamp authorities, which would take far more than 60-day period that is laid down by section 1113. Undoubtedly, section 1113, which was introduced by the Amendment Act 3 of 16, was enacted keeping one of the most important objectives of the 96 Act in mind, namely, speedy disposal of disputes by the arbitral tribunal and appointment of an arbitrator having to be made as expeditiously as possible. Therefore, thus, a harmonious construction needs to be given to the provisions of the Maharashtra Stamp Act and section 1113 of the 1996 Act, by which, if it is possible, both provisions ought to be subserved. Now, how it is done is at para 37. The time limit is put in by way of a declaration. Para 37 minutes, page 88. One reasonable way of harmonizing the provisions contained in section 33 and 34 of the Maharashtra Stamp Act, which is the general statute insofar as it relates to safeguarding revenue, and section 1113 of the 96 Act, which applies specifically to speedy resolution of disputes by appointment of an arbitrator expeditiously, is by declaring that while proceeding with the section 11 application, the High Court must impound the instrument which has not borne stamp duty and hand it over to the authority under the Maharashtra Stamp Act, who will then decide issues, payment of stamp duty and penalty, if any, as expeditiously as possible, and preferably within a period of 45 days from the date on which the authority receives the instrument. as soon as stamp duty and penalty, if any, are paid on the instrument, any of the parties can bring the instrument to the notice of the High Court, which will then proceed to expeditiously hear and dispose of the Section 11 application. This will also ensure that once a Section 11 application is allowed and an arbitrator is appointed, the arbitrator can proceed to decide the dispute within the time frame provided by Section 29. So 12 plus. So it is by this declaration that please do it in 45 days. Now, my lords, arguments taken of prejudice, namely on the facts of this case that the appellant had to pay stamp duty and cannot take advantage of his own wrong, are of no weight when it comes to the application of mandatory provisions of law. Even this argument must be rejected. Ultimately, the court remanded the matter to the single judge of the High Court. Now, next, my lords, is Dharma Ratnakar, the three-judge bench, my lords, which follows SMST. Again, this is the second three-judge bench, not noticed in NN Global, page 89. Here, my lords, facts, brief facts, my lords, page 91, para 9. In a suit, a Section 11 application was filed. In a suit, a Section 11 application was filed, and then the registrar of the High Court, my lords, was entrusted with the responsibility of assessing the duty and the nature of document. The registrar, my lords, made a report that X amount of duty is liable. Admittedly, the duty was not paid. I will show it from the judgment. Yet, the Honorable High Court proceeded with the appointment of the arbitrator. The 11-6 was allowed. Therefore, my lords, in that context, the SMS judgment was noticed. This case, my lords, is under the Karnataka Stamp Act, identical provisions. There is no difficulty. Please have para number 17, which is at page 94.
Yeah.
Just have the last 3 lines of para 16, the issue. In this background, a question that would arise for consideration is as to whether clause 36 in the lease deed dated so and so could be acted upon to enforce the arbitration clause contained therein. So now para 17 shows the issue is no longer res integra. This court in SMST had occasion to consider the provisions which are pari materia with the provisions of the Karnataka Stamp Act. SMST is Indian Stamp. Identical because entire provisions are quoted, the judgment is quoted. Now see para 18.
Yeah.
It is thus clearly be seen that this court has in unequivocal terms held that when a lease deed or any other instrument is relied upon as containing the arbitration agreement, the court is required to consider at the outset whether the document is properly stamped or not. It has been held that even when an objection in that behalf is not raised, it is the duty of the court to consider the issue. It has further been held that if the court comes to the conclusion that the instrument is not properly stamped, it should be impounded and dealt with in the manner specified in Section 38 of the Stamp Act. It has been held that the court cannot act upon such a document or the arbitration clause therein. However, if the deficit duty and the penalty is paid in the manner set out in Section 35 or 40 of the Stamp Act, the document can be acted upon or admitted in evidence. It is needless to state that the provisions that fell for consideration before this court are analogous with the provisions of Section 33 and 34 of the Karnataka Stamp Act. In this view of the matter, we are of the concerned view that in view of the law laid down in SMST, that the lease deed containing the arbitration clause which is required to be duly stamped was not sufficiently stamped, and though the registrar judicial had directed respondents 1 and 2 to pay deficit stamp duty and penalty of so and so, the respondents failed to do so. The High Court has erred in relying on the said deed. So clearly SMST followed. Now, ultimately, para 25 will show that because duty was not paid, Section 11 application itself was.
Yes, only 3 questions were actually formulated.
Yes, right.
3 questions that is in para 9.
Right.
What were the questions framed and considered?
And it has been consistently followed. And this judgment came in February 2020. The Dharma Ratnakar by 3 judges, lastly following SMS.
But prior to 6A.
Yes, because 6A, according to me, I just put it, is already slated for omission.
No, as on today,
it stands. Therefore, the question which fell from the, what is the scope of examination? Even the prima facie do that. What is the scope? Now, just to point out one small fact.
That will be dealt with by Garwari.
That is dealt with by Garwari. That is the first judgment which has 11.6A.
No, that's deletion. That provision for deletion Effect of that also, I think, has been considered.
No. Deletion has not been.
It was considered. Even if it is deleted. Huh?
Karwade notes that it has been deleted, but it,
And even if it is deleted, that also was considered.
my lord, there is that is mentioned also in another judgment, which is my lord, the BSNL Nautel. I have not cited it, but where even if it is deleted, it is to be considered.
That's what you brought to a notice, sir.
BSNL Nautel, my lord, considers it. I have not given that judgment, sir.
What is the citation?
That is, my lord, 2021
Just one minute. BSNL.
versus Nautel. My Lord Justice Rastogi was a party to that judgment. 2021 5 SCC 738.
I said it was considered.
Considered and my lord. Para 35, your lordship should see. In fact, my lord, in one of the recent judgments in Weatherline or there is an error, my lord, there is an error.
It has been omitted already.
It has been omitted altogether. That's not correct.
That's not correct.
That's not. My lord, your lordships will just see page 761, 29 amendment to section 11. Para 35, it's 761. And that is the omission, my lord. But then para 37, after the amendment, 2019 amendment is notified, it will result in deletion of 6A and the default power will be exercised by arbitral institution. So it has not been notified. So as on today, my lord, 6A subsists. Whether it will subsist tomorrow or not, my lord, we don't know. But whatever your lordships will observe here, we may have some impact even for instance. Yeah.
With this, can I just show page 98 of this convenience compilation on same. This matter was heard 23rd November 2020. Judgment was reserved.
Which one?
NN Global.
Oh.
Matter is reserved for judgment. Vidya Dolia comes in December 2020. Vidya Dolia rightly notes only the issue of subject matter arbitrability was there. But I would beseech your lordships to please have a look at para 23, 126, and then 146, 147 that your lordships have.
Of Dolia.
Yes, Dolia again. 23 in fact. 23 is at page 147.
Yes.
An arbitration agreement must satisfy the objective mandates of the law of contract to qualify as an agreement. Clauses 2G and H of Section 2 of the Contract Act state that an agreement not enforceable in law is void, and an agreement enforceable in law is a contract. As a sequitur, it follows that an arbitration agreement that is not enforceable in law is void and not legally valid. But my only submission is, as put earlier, it would be an eclipse. Since the Stamp Act was not considered, this observation is not made in relation to the Stamp Act. So it is void, yes, only to the extent till that bar operates. The moment you pay a stamp duty, it is admissible.
But that is not correct to describe it as void.
It is void because it is not enforceable. It is not enforceable because stamp duty is not paid.
Void gives the impression that it's
Perpetuity.
perpetuity.
Perpetuity. In fact, it would, morning, it came from the bench that it was temporary. The word is temporary non-existence. So temporary non-existence or temporary void, whatever the expression that we use, it is not void in the sense that void in from the very beginning and continues to remain void. It is operative, eclipse, enforceability due to the Stamp Act bar, stamp duty is paid, bar is removed. It is as simple.
That explanation is based on the Indian Contract Act.
Yes.
Because 2G. 2G, it also says that an agreement not enforceable is void.
Void.
That is why.
That is why. Look, in fact, Justice Nariman's judgment, para 22, Once it discusses section 2G, it has a comma. It says unless it is duly stamped. So the expression of, please come back to 22 of para 22 of Garware. That is Millard's page 79. Page 79, Garware. I'll read it. When an arbitration clause is contained in a contract, it is significant that an agreement only becomes a contract if it is enforceable by law. We have seen how, under the Stamp Act, an agreement does not become a contract, namely, that it is not enforceable in law, unless it is duly stamped. So this observation of this voidness, unenforceability is limited to the time it is not stamped. The moment it is stamped, it is enforceable. Now, because I want to show para number 126 of Vegetative, where Miller's the scope, the principle of separability and legal fiction is dealt with respect to section 16 of the arbitration. That's at page 205. We would now examine the principles of separability and competence. Clauses A and B to subsection 1 of section 16 enact the principle of separation of the arbitration agreement from the underlying or container contract. Clause A, by legal fiction, gives an independent status to an arbitration clause as if it is a standalone agreement, even when it is only a clause and an integral part of the underlying or container contract. Clause B formulates a legal rule that the decision by the arbitral tribunal holding that the main contract is null and void should not ipso jure entail invalidity of the arbitration clause. Successful challenge to the existence or invalidity or decision of the main contract does not necessarily embrace an identical finding as to the arbitration agreement, provided the court is satisfied that the arbitration clause have been agreed upon. The arbitration agreement can be avoided only on the ground which relates directly to the arbitration agreement, notwithstanding the challenge to the underlying or container contract. The arbitration clause in the underlying or container contract survives for determining the dispute. The principle prevents bootstrapping, as it is primarily for the arbitral tribunal and not for the court to decide issues of existence, validity, and decision of the underlying contract. Principle of separation authorizes an arbitral tribunal to rule and decide on the existence, validity, or decision of the underlying contract without an earlier adjudication of the court's referred questions by the referral court. Now, according to me, I am relying on this to show that 16(1)(a) is a legal fiction created for a definite purpose. And I will show from NN Global that it is this principle which has been extended to the Stamp Act. Now, let's please have, now your lordships may come to 200.
Sir, just if you come to the question which has been referred by in your case, at page, paragraph 58, the question which has been referred to us, we have to go back to that finally.
Yes.
So what does it say? Whether the statutory bar contained in section 35
would also whether the statutory bar contained in section 35 of the Indian Stamp Act applicable to instruments chargeable to the stamp duty under section 3 of the section 3 read with the schedule of the Act would also render the arbitration agreement contained in such an instrument which is not chargeable to payment of stamp duty.
That is an error. That has already been pointed out. That's okay.
As being non-existent, unenforceable.
So go there a little slow. As being non-existent.
Non-existent.
So what is your contention about that?
It is there. Now it is there for what? And you can look at it.
Say it is existent.
It is existence in physical form. It does not exist in law because it is not enforceable and the bar operates.
I think we are going.
That
you should say that it doesn't exist in law. Is that also correct? Because it is not stamped. Can you say it doesn't exist in law? And we will just, take the next expression, unenforceable. We are going to give an example and then ask a question. Supposing there is a unstamped agreement.
Yes, please.
Correct? The parties don't go under section 9, section 11, So, the arbitrator who is actually agreed to join, they go on with it, they pass, an award is passed. Silks. It goes in. Then the award is properly stamped. I'm giving an example.
So it is an award duly stamped, which is based on an agreement which is not stamped.
Which is not stamped. So during that period when orders are passed and then all kinds of orders are passed by the arbitrator, see, he does that. I mean, so what happened there?
According to me, Section 36, then of the Stamp Act to come into play.
The arbitrator, you say, will have to naturally involve it.
The first duty was of the arbitrator, because the bar operates. An arbitrator, like all, he is supposed
Will the entire thing collapse, or suppose at the stage of Section 36 execution, the award along with the agreement is produced?
What we will slightly modify that example a little bit. Supposing there is an unstamped agreement, parties actually get to perform their duties, mutual obligations. It's a civil work, construction work. They perform all their obligations, payments are made almost, at some point a dispute arises. So again we put to you, can you say that it was unenforceable in the very beginning? And
may I answer this by showing two provisions, Section 36 of the Stamp Act, and then read with Section 61 of the Stamp Act. Section 36, I'll read. Admission of instrument where not to be questioned.
That's subject to 61.
Subject to 61. 61 says if the document has been acted upon, entered, then it provides consequences. What are the consequences? Please have 61. When in any court in the exercise of civil or revenue jurisdiction or any criminal court in any proceeding under Chapter 12 or Chapter 26 of the CRPC 1898 makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp or upon payment of duty and a penalty under Section 35, the court to which appeals lie from or references made, such first mentioned court may, of its own motion or an application of the collector, take such an order into consideration. If such court, after such consideration, is of the opinion that such instrument should not have been admitted in evidence without the payment of duty and penalty under 35, or without the payment of a higher duty and penalty than those paid, it may record a declaration to that effect and determine the amount of duty with which such instrument is chargeable, and may require any person in whose possession of power such instrument is then to produce the same and may impound the same when produced.
The referring bench, the substratum is actually erroneous. Why we tell you, again we are just reading it. Whether the statutory bar under Section 35, etc., applicable to, would also render the arbitration agreement contained in such instrument, which is not chargeable to payment of stamp duty, as being non-existent, unenforceable, or invalid, pending payment of stamp duty on the substantive part. So the whole question is actually based on a wrong premise, because it proceeds on the basis that agreement for
main agreement requires stamp duty.
The main agreement
does not require.
So two, three things. One is that there is the agreement to for arbitration is a separate agreement, part of a larger agreement. The larger agreement may be exigible to duty, but the agreement for arbitration not exigible to duty. In such circumstances,
what is to be done? That's in my respectful submission.
This is how
question
has been raised.
There is a small catch in this. The bar applies to the entire instrument, not to a transaction. This agreement is stamped, that agreement is
not only that, the other agreement is also stamped. It
requires stamping.
Both ways it is wrong.
Because I'm sorry to say this, because nothing of this was argued. Para 5.1, 5.2 of the judgment, our submissions were only twofold. Writ petition against an order dismissing a Section 8 is not maintainable. That contention is upheld by the NN Global Judgment saying, sorry, writ is not maintainable, appeal is there. Our second contention before the court was, sir, it is an unstamped agreement. Please follow the line of SMS, Garvaye, which is followed by so and so. it is in this context, my lords, that all this, my lords, the matter lasted for 2 minutes. It was a Monday, VC. He never argued all this. Our submissions are rightly recorded only in 2 paragraphs. 5.1, we argued our submissions. 5.2, the only argument by the other side was, if duty is payable, please give us opportunity to pay duty.
No, the NN Global fundamentally has split into two. The contract on the one hand and the agreement of
The arbitration, the main agreement and the arbitration.
That's why they say doctrine of separability.
That's the foundation of NN Global.
And that's why this question is framed. That's why this question is framed.
And
So you look into this question once again.
Yes,
Mr. Banerjee.
Well, no, that's why I said
What
that
is
I am
this? You also see, if we can convert it, whether the statutory bar, you see this question.
My lord, therefore I had knocked out, my lord, some words.
We have something more also with you.
Yes.
Whether the statutory bar contained in section 35, Stamp Act, applicable to instruments chargeable. Instrument include both.
Yes, my lord, that I have, my lord, mentioned.
Chargeable to stamp duty under section 3 read with the schedule to the act, and deed also would render the arbitration agreement contained in such an instrument as being non-existent, rest below, pending payment of stamp duty on the substantive contract. It will not work.
My lord, that is what I had suggested, my lord. Your lordship, see, I
both of
blue lined, my lord, some portions on that basis.
Because the very foundation on which global goes on, if that principle is not acceptable of splitting the agreement into two and say agreement,
Lord, that's why
arbitration is a separate agreement.
That's why I had
Not
said.
be stamped.
It has two.
My lord, I said that at the beginning, my lord, that it is both have their own problems, but certainly, my lord, this question does arise because this the fundamental in this question is that the assumption in Garwade is because it was non-existent, therefore, my lord, it is in law. Therefore, my lord, 11.6a applies. If it is existence in law, my lord, then 11.6a will not apply. So, my lord, this question has been reformulated and, my lord, recalibrated.
Even if we see para number 7, if your lordships would just have volume 1, para number 7 of NN Global, it states
there are some
application, this bar would apply. How?
There are some portions of, I have not placed NN Global, there are some portions of NN Global which also, my lord, address this this bit also and say, and sustain, my lord, this reformulated portion also. 3-4 paragraphs are there. I have deliberately, my lord, not in the interest of time, not presented the entirety of NN Global. This issue was also there. I can show, my lords, for instance, paragraph 24, first sentence. It's there. My lord may just see, for instance, sentence at para 22, first sentence.
Where is NN Global?
NN Global, my lord, starts.
Not you.
Hold on, my learned friend has put a reported copy.
261.
Please see 292, for instance, my lord. 292 of my learned friend's compilation. Para 6.2. First sentence. In our view, my lord, please see para 6.2 of NN Global. The non-payment or deficiency of stamp duty on the work order does not invalidate the main contract. So, my lord, here there is no problem regarding splitting into two. Section 34 provides an unstamped document not be admissible in evidence acted upon requisite. This would only amount to a cure deficiency which can be cured on the payment of requisite stamp duty. Lord, therefore, 6.2 says nothing about, my lord, splitting it into two agreements. So this point has also been, my lord, articulated. It is not that it is entirely based on this issue. So, my lord, there are 3 or 4 paragraphs which also address this on this demurrer. It doesn't mean, my lord, that the entirety of the judgment goes.
Yes.
Please have para 6.4, page 292.
Yes.
That is separability. The arbitration agreement contained in, I'm so sorry.
Yeah.
The arbitration agreement in the work order is independent and distinct from the underlying commercial contract. The arbitration agreement is an agreement which provides the mode of dispute resolution. Section 3 of the Maharashtra Stamp Act does not subject an arbitration agreement to payment of stamp duty, unlike various other agreements enlisted in the schedule. It is for this obvious reason that an arbitration agreement is an agreement to resolve disputes arising out of commercial agreement, though through the mode of arbitration. Now, please mark this. On
One
the
thing,
basis
sir,
of
it is the resolution of the dispute in offer or what is dealt with under the main
contract. It's a bullet.
So without looking at the main contract, how you will decide what is available for arbitration?
Now let's just mark.
Because subject matter, one can understand what exactly is the subject matter only by looking into the main contract.
And the scope of an arbitration, whether this dispute at all would be arbitrable. You may have an accepted matter. You may have an accepted matter.
Because see, main contract and this
the
arbitration, they are not actually dealing with the different things. They are not.
It is a mechanism to solve your disputes. Why the main agreement?
There is a note of the subject matter in the main contract.
Now let's carry on with 6.4. On the basis of the doctrine of separability, the arbitration agreement being a separate and distinct agreement from the underlying commercial contract would survive independent of the substantive contract. The arbitration agreement would not be rendered invalid, unenforceable or non-existent, even if the substantive contract is not admissible in evidence or cannot be acted upon on account of non-payment of stamp duty. Here, Millards, two concepts, Millards. One, separability is a legal fiction. Again, I'm repeating, definite purpose. It can't go on to a stamp act. Number one. Number two, the bar applies to an instrument. The instrument contains your main contract and your arbitration agreement. It does not say this part is void, this part is good, this part is bad. It is the entire instrument which has to be eschewed from consideration. The main
the agreement for arbitration, will it be an instrument? It will be. So it will be a separate instrument.
Because instrument is defined.
Instrument within an instrument.
Because instrument, if we see the definition of
because section 5 and 6 speaks about the duty to pay stamp duty.
Right.
When you have many instruments, and then will be paid on the duty which the agreement which attracts the highest duty.
Because I will place before your lordships, once I go to the Stamp Act, section 5 of the Stamp Act, and then basically section 3, which is the charging section, then section 5. Then there is a complete mechanism in the Stamp Act itself. When it is to be paid, who will pay, if he does not pay, if he is in doubt that how much is to be paid, he can send it to the collector under 30. There has to be, and then there's no time limit, 31, it can pay. If person A, responsible person B pays 44, will apply. It's a completely defined mechanism. In case of a dispute, the collector can refer it to the Chief Revenue Authority. He can refer the matter to the Honorable High Court by making a statement of case. It's a completely different mechanism. And ultimately, what are we looking at? We are looking at the issue whether or not you have paid stamp duty. Simple. A, it can be in two ways. On the face of the document, it would be on a stamp paper. If you have paid it, because section 17 says at or before executing the instrument. That's the time that you paid. So you would have a stamp paper. If you don't have a stamp paper and you choose a section 30 mode, 30 and 31 mode, you will then have a receipt of actual payment, which is in the form of a stamp paper, that wherever you put the contract would form part of the agreement. That, sir, on the face of it, the first page it is not stamped. I have paid stamp duty, it is here. Or the agreement itself will show on the first page. In our case, for example, 200 rupees was payable, 100 rupees plus 200 rupees stamp. This is the
Banerjee's argument is that look at the object of the Arbitration Act.
Yes.
You want to have speedily, you want to attract international arbitration, you want to become an arbitration hub like Singapore. So how do you do this if you're going to be stuck at the first stage?
Because I'll answer that very simply.
Chronology of state.
Because our desire to make India an arbitration hub, this desire to project it, can it be, Milords, at the altar of saying that please don't look at the law? Now, because effectively what is being said? In section 11, there is a duty to pay stamp duty, right? It's your obligation. Under the Stamp Act, if it is chargeable, you have to pay stamp duty. Person A violates it, not paying stamp duty. Then comes to court, saying that, sir, I may be liable, I am liable to pay stamp duty, there's a so and so, but you also now don't look at the bar at 35. You go and appoint an arbitrator. Please appoint the arbitrator. So you commit another error by overlooking that bar. Is this argument?
As he says, you're just
cannot be acted upon or is rendered unenforceable in law.
Mr.
David is here.
Mr. Goel, just give us the corresponding paragraph in SCC.
This is para 28. Thus, according to me, the caveat has to be till it is duly stamped. An arbitration agreement would be invalid where the contract or instrument is voidable at the option of a party, such as under section 19 of the Indian Contract. We hold that since the arbitration agreement is an independent agreement between the parties and is not chargeable to payment of stamp duty, the non-payment of stamp duty on the commercial contract would not invalidate arbitration clause or render it unenforceable, since it has an independent existence of its own. Again, separability comes in.
again that is wrong because it is itself exigible to duty.
That's apart. Now, please have a look at text. The view taken by the court on the issue of separability of the arbitration clause, mark this, on the registration of the substantive contract ought to have been followed even with respect to Stamp Act. The non-payment of stamp duty on the substantive contract would not invalidate even the main contract. It's a deficiency which is curable. There's no doubt it is curable. Now, my grievance is, now look at the sentence, the view taken by the court on the issue of separability of the arbitration clause on the registration of the substantive contract. Two completely different provisions. Section 49 proviso permits you. Section 35 creates a bar. Doesn't remove it until duty is paid.
Banerjee kind of sought to also argue that admissibility and admissibility of a document, that question may not arise at the section 11 stage. He drew parallel to a suit.
Okay.
After discovery, admission of document.
My contention is very simple. How do you discover stamp duty is paid or not paid? Just look at the document. Look at the agreement. It will be either on a stamp paper, your first page, second page, third page, or the stamp duty, once paid, would have a certificate, endorsement. You will have stamps, e-stamps attached to it. And whenever you will file such a document, an agreement, you will at least, now that you know it requires, you will enclose those pages also. It would form part of your agreement. So is it such a difficult stage, such a difficult thing that a section 11 court would not look at it? Because what are we looking at now? At a stage where we have to see the bar created by 35. It applies to the entire instrument. Admissibility, not to act upon. Till what? Till duty is paid. What is to be done?
But it is, whether it is sufficiently stamped, it requires consideration.
Because I will come to that. For that, I will show section 29 of the Stamp Act. In your instrument, you have to disclose all material facts which affect the chargeability. Now, because there is a judgment of this court, because if you also want, I'm sure. The agreement said, for the agreement to set, agreement to sell said possession has been delivered. And according to the concerned Stamp Act, it was to be stamped.
And, Tuesday, that's all we get.
Mr. Banerjee, and you also, if the question has to be reframed,
It has to.
do it and give it to us.
My lord, I have made one attempt, as your lordships have seen. I anticipated this problem, my lord, therefore I deleted some portion.
Well, this question will not work. Because they have proceeded on the basis of splitting the contract.
The foundation is wrong.
My lord, I have deleted that portion of
If
the.
you are going ahead with splitting, the splitting business will not be there.
Splitting business will not work with stamp duty. My lord, I had said that right at the beginning.
That's why you have a reform.
I have reformed. That's why I have reformed. Deeply.